most important things that you do is there's a general rule, and that is that the public's business should be done in the open. Now, just listening to the number of years you guys have been at it, there's some that have been at it less than others, and others that have had a lot of experience with it. And so I thought tonight maybe what I might do is just to put some scenarios out to you and ask what the best practices are, what you found to be the best practices in the time that you've been here. Some of you have been here a long time and gone through a lot of different scenarios involving open meetings. And so I'm going to put some questions out to you and tell me how you would resolve those issues, or what comes to mind, your experiences when it comes to dealing with the open meetings provisions of the state law. First of all, quorums. What does it take to have a quorum? What's the quorum here? We got
a quorum here.
A quorum in city council is
6, 5, I guess. I don't know.
It's a majority of members.
Majority, yeah. Oh, I see.
So
of voting members.
Of voting members, right. Yeah. And in the case of the mayor, she doesn't vote. It's a 6-member council form of government, right. But she only votes in those rare circumstances where it deals with her powers, deals with the appointment of the city manager, or something to do specifically with the mayor's authority, and that's, or breaking a tie is the other one. So all other times, a quorum has to include 3 members of the council. What if you have 2 members of the council and the mayor? Is that a quorum? It's not. That is not a quorum. How about the planning commission? Say you have a majority, almost a majority of the planning commission members there, which is 4, right? Yes. You've got 4. And one of those members is the chair. Can you use the chair as a voting member of the planning commission?
No.
He brings a tie.
Yeah. Okay, so the same rule that applies to the mayor does not apply to the planning commission. So that was a trick question. I'm sorry, George. I told you I was going to get you. You sat in the corner. I told you this is it. So
that's why it's a training process.
That's right. That's exactly right. And that's how you learn. But for a long time I thought that was the case. But the same rule doesn't apply to the planning commission as it applies to the mayor. You're always a voting member, even when you sit in the chair position. Let's talk a little bit about some of the preparation that goes into our meetings. Kim, how far in advance of a meeting do you have to actually advertise a meeting?
24 hours.
24 hours, right? What about a hearing? Is there a difference?
There is. There's statute.
Okay.
Stipulates certain timeframes associated with that.
Okay.
Some of them are business days.
Mm-hmm.
Some of them are days, which include weekends. Isn't it usually 14? Comes to my mind.
So they changed it to 10
used to be.
for the planning staff or planning decisions. But planning is one area where you got special provisions regarding notice. Taxes are another, right? And every once in a while you find in the code a provision that says you have to advertise within a certain number of days. But otherwise, the general rule is 24 hours, right? For a public meeting. Public hearings a little longer if it's designated in the code for a little bit longer. Now, let's talk about the materials that you get. And I'm going to kind of mix some things up. Can the planning commission ever have a closed meeting? Can you guys ever close the meeting and say, we're going to go in the back room, we've got to consider this application, and then we'll be out?
We can. It might not be legal.
We put him in the corner for a reason.
Right?
This corner for a reason.
Right?
You're right, you can. And it would not be legal for the planning commission to have a closed meeting.
Okay.
How about, we shifted from a board of adjustment for appeals. Your planning commission appeals now go to a hearings officer. Can the hearings officer retire and ponder the issue and then come back and talk to himself and then or herself and come back and give an opinion? Yeah, even the Board of Adjustments used to be able to do that. They could close the meeting and go back and make those decisions. But the Planning Commission is the only body that can't do that. City Council can, but that creates greater liability for the City Council, right? Because what are some of the things you can be liable for in a closed meeting? What are some things you can't do?
No, you can't discuss it outside of it.
right?
Can't make
The
any
stuff
decisions.
The stuff,
Can't
and you
make
can't make any
decisions in it.
decisions, okay? And what about, you can't make any decisions, you've got, let's see, oh, yeah. It's actually a violation of the open meeting, or of the, grandma, because the records of a closed meeting are protected. And because they're protected, you can actually be guilty of a class B. See, their liability is a lot greater than yours. We push all your liability out of the way because we don't let you hold a closed meeting. And then we say to these guys, you make sure you only hold it for certain reasons. What are the reasons?
Personnel, land purchase.
Personnel, land purchase,
and
Liability.
and liability. Like immediately pending litigation.
Litigation.
For
What about
security.
security?
And security, yeah. The other thing that you need to know is that if they slip sometimes and begin to discuss the zoning application that is on the agenda for the next meeting, and they kind of combine that with maybe a discussion of pending litigation over a road or a piece of property, can you do that? No, because once you slip into discussing other things in a closed meeting, then you become liable or responsible for violating the Open Meetings Act. So those are just some of the things that they can get into trouble for that you can't get into trouble for. And I keep telling them, one call, that's all. I give them my card and let them know that if they do violate that, we're in good shape. So some of the things that, field trips, planning commissions take a field trip.
Yeah.
Are those open meetings? Yeah. I love it. You shake your head right at the right time,
Well,
Jeremy.
I have a question though.
Yeah.
When I go out by myself to do a survey, that's not a meeting, is it? Because I'm by myself.
Great question.
Do I have to invite the public every time I drive, like with my kids in the back seat, to go look at a site?
Only if they're planning commissioners.
They're not planning
And you're good.
Future, you're
You're
training them, right?
That's right. Future planning commissioners don't count, but it's a good question, an excellent question. So when do you have to advertise a meeting? When there's,
Depends on which body, on how many.
okay, all right,
You have to have majority.
okay.
2 or more for us,
Right? 3 or more,
3 or
right?
more, I mean, yeah.
The mayor can go out with 2 members of the council, no problem. But you add that 3rd member of the council, you got a violation of the act. Planning commission, if 4 of you get together, that's a violation of the act. Okay? Only if, now here's the if the meeting is convened for the purpose of doing the public's business, right? Like if you're going out to dinner together, you just happen to want to go out to dinner together and you're not talking about anything, social visits, social get-togethers and that type of thing, does that count? No, of course not. However, if you start to deliberate over the application and the purpose of the dinner was to get together so we could discuss what we're going to do with 107 acres out west, you've all of a sudden got a meeting. Okay, scenario. What restrictions do you have on use of your cell phone? Okay, any at all? As a result of your positions on the planning commission and the city council, what can you do with your cell phone during a meeting, outside of a meeting? What types of things might constitute a violation of the Open Meetings Act in using that cell phone?
Communicating between other members of the same body.
Exactly. Yeah. Right, during a meeting, you can't do that. You can't be texting each other during a meeting. I recommend you don't even whisper during a meeting because it's really, really bad, especially on camera, to see 2 people whispering up there and the applicant standing down there wondering what they're saying and the public wondering what they're saying. So even that type of communication I think is bad, but texting is out. You're not allowed to do that. How about 4 of you in the planning commission that all get together on the phone and communicate with each other just on a phone call is that a good question? On what? So if you're just talking about going out to dinner, no problem. But the instant you begin to deliberate or convene the meeting for the purpose of doing the public's business, which you're kind of doing when you're asking questions, that creates a problem, right? So you got to be careful. What about, I would stay away from using your cell phone at all when you're up on the dais, because nobody knows what you're doing, and avoid the very appearance, right? You can do that. So that's what I do. So let me talk about just for a second, we don't have very many minutes left on open meetings, but what about the materials that you get? Materials that are produced for the council in a closed meeting, obviously you can't share, right? Okay, unless the council all agrees in an open meeting that what you just discussed in the closed meeting can be shared and can become public. You can change the status of that. Simply in a public meeting, you can do that. But, okay, you get a packet before the meeting. That packet has not been put on the website yet. It has not been, nobody else has seen it except for you. It's sent out to you to get your comments. If you have something that needs to be changed, that you would like to be changed, even though you don't do it very often, that is the reason for sending you the packet in advance, so you can become educated and know what's in the packet, right? At what point does that become public information that you ought to share?
When it's posted on the website or in the meeting.
Right, yep. So up until the time that it's posted on the website or in the meeting, it's yours for the purpose of being able to, because that might change. It might change. You might see something on the agenda that you say, well, you know what, this has kind of been resolved. And there may be some change in the documents that are sent out to you. Staff oftentimes will recommend a change because up until the date of the meeting, everything's in flux. And so be careful what you disclose before the meeting and make sure that what you disclose is the information that will be made public in the meeting. Question?
What if I call Zach and ask his opinion?
On something that was in the packet.
It's in the packet, and I call Zach.
You've only got, tell me what the concerns might be.
So, I don't know.
Well, so you got two people.
There's two people.
You don't have a quorum, right?
Don't have a
Okay.
quorum.
Can they talk about an issue that's on the agenda?
I would assume you could.
Sure you can.
Okay, that's,
And then what about talking about stuff that's on the agenda between the council members?
members.
Yeah, just talking about information with, say, 3 council members.
That's wrong. We know that.
Okay.
So the third person
Would
on
make
council makes a problem.
Would make a problem, yeah. So, trying to think of anything else that you have a question on when it comes to open meetings? Because that's just a really, really.
Why don't you make your comment regarding, like in public comments?
Okay, yes. So, the courts in the state of Utah will take what you have said in a meeting and they will add all of that up as being the reason you made a zoning decision. So in other words, as you speak in a public meeting and the things that are recorded in the minutes, and by the way, which minutes are correct? Are they the recording or are they written?
Written.
Okay. So really it's incumbent on you to make sure that what you said in the meeting is in those minutes, right? But okay, so those minutes come out. The court has allowed us as attorneys to use everything you said in the meeting and put it together and say, this is Zach's reason for voting the way that he did. And if they're looking to prove bias or invalid decision because it wasn't based on rational basis for zoning decisions, or you didn't have substantial evidence for administrative decisions, they're going to look to that record. And the thing that worries me sometimes is you get a case where you got a serious decision to make and you don't have enough on your record to be able to establish that you did have a substantial basis for a subdivision approval, for example, or a conditional use. And so you really need to fill those minutes up. It doesn't mean you talk all night. No filibusters, please. All right. But you can talk and put your reasons when you make your vote is a good reason or a good timing for doing that. Typically, what the mayor will do is they'll say, "Do I have a motion?" For motion, second. Is there any discussion on the motion? And that is the very best place to stick in your reasons for voting the way that you did. Do you need to do it every time? No. But if you got a controversial hearing, please make sure you fill those minutes with your reasons, because We have nothing if you don't do that. Even on appeal to the administrative officer, the appeal authority, we have nothing if you don't put something on the record.
Does the work meeting count?
Work meeting counts.
So I mean, if you
Yeah.
mentioned it in the work meeting, it's not,
Yeah, it's an
Okay.
open meeting, yeah.
okay.
And so those minutes are extremely important to us because the way our code reads, an appeal is only on the record. We don't allow any additional information. So when we get an appeal from your decision on a subdivision application, for example, I can only look to the minutes, or the zoning appeal authority can only look to the minutes. Bettina, I'm sorry.
So and Tyson had a question, also a comment, but you're saying that the comments we make need to be recorded in the minutes in order for that to be on record. Sometimes, there's a lot of discussion, so there'll be a summary of the general feel of what happened and not necessarily specifics about Zach said, Bettina said, whatever. Because we are live streaming and things are video, and I know that's not the permanent record or the official record, is there a way to utilize that to fill in those blanks? Because I would imagine Ken's not always going to write every single thing down that everyone says. How do you mitigate that?
So you'd be expected to go through the minutes, and if you feel that something extra needs to be put in there, and I've seen the council do that before, where they've said, I said these things, and I want those in there. You have the right to do that, and that's why we approve the minutes after the meeting, in the subsequent meeting, is to give you time to look at them and say, that's not what I said, or I need a little more here. This is the reason I said the things I did. They often quote me, and they always quote me wrong, right?
Always.
Attorneys always quoted wrong. So anyway, it's your opportunity to correct that and make it on.
But on
Yeah.
those lines though, when you guys do get your packets and you read through the minutes, and if you're not comfortable with the way it's stated, then at that point, get a hold of Kim so she can actually cross-reference it as well and make sure she's got it accurate.
Or
So
just
that then
say-
when we come to our meeting and we're ready to adopt it, one, it gives her time to either get it corrected and back in time, or we have a copy there has a corrected version.
Or if you want to say specifically, I want to be on record
Yeah.
with this comment.
Very much so. Yeah, you can.
As long
I
as it's
appreciate
stated
when you
in
do
that
that,
meeting and you're not changing your position or trying to add to a position.
Right.
Right. Yeah.
Okay.
If you're gonna do that, you need to do it by motion, right?
Right.
And it would be the same. A person who voted against it must make the motion to reconsider an application, and then you can go opposite to what you decided in the prior meeting.
May I add something?
Sure.
I like when you said, Gary, that when the mayor calls for discussion, that's the appropriate time for you to make your comments, because at that point, that is my signal to pay attention and get your comments. Like you said, I summarize a lot in the meetings, and those, up to that point, will be a summarization of what was taking place at the meeting, but it's not a lot of detail. But once the motion is made, that's the sticking point right there. Thank you, Gary.
So I was gonna put a summary together.
So I'm playing that out in my head. So we make a motion that we send an affirmative thing off to the, right? And get a second. And if somebody else makes that motion, I'm gonna vote against it. And Brett then asks, is there any comment on the motion? Is that when I say I'm going to vote against, I am not going to vote for this because of this?
Yes.
I say that before I vote.
The fors or against can put a comment on the record at that point, and that would be the best point to do
The
it.
best point would be before I vote.
Yeah, before you vote.
Okay.
During
But
discussion.
then
During discussion.
and then she still calls for the.
And then then you call for the vote.
Does that make sense?
Yeah.
That's good. Okay.
Yeah.
That's really helpful for the attorneys.
For me.
Right? Okay.
So is it, on that, Gary, because I think, Mason, I think you had us one time, it was a roll call vote, and just stated, right before not during discussion time, while the chair was taking the vote, said, I'm voting no, and this is why. While they're taking the roll call vote.
Like,
Well, that was wrong.
It's
That
one
was
way better than the other. Sorry to throw names out there.
I knew he was here and I was just getting ready to talk about it. No, that would be just as appropriate if you want to do it there. It's kind of fun to collect it in one place, but if you don't, it's okay. That's close enough to any discussion on the motion. That's a good thing. So, sir.
Let's say it's a 4-1 decision. What's the benefit of me putting on the record my single lone dissenting vote that has absolutely no value?
Yeah. There are a couple of times in my practice when that has made a difference. One of the times in my practice when it has made a difference was subsequent to that, the vote came back as a result of that person who voted negatively and lost the motion. It came back because essentially the things that were said were important enough that the council thought about it. In the next meeting, somebody who voted in favor of the motion actually voted to bring that back because of that one person who had raised issues.
It's like writing a sole dissent within someone.
That's it. That's it. You got it. Yeah. So, all right. All right. Conflicts of interest. We'll make this simple because I'm running against time here. But conflicts of interest. Let's go to the next slide. So I'm just going to summarize this real quick for you. If you do business with the city, you have to file a conflicts of interest form. If you are licensed by the city, you have to file a conflicts of interest form. If you own a business in the city and are business license in the city, you have to sign that conflict of interest form. In the case of a situation where you're doing business with the city and you're coming in and you want to make a presentation to the city or somebody's making a presentation to the city on something you're selling to them, you actually have to actually declare it in a public meeting. So those are just, so in other words, whenever you're doing business with the city and you've got a pecuniary interest, a dollar issue, some type of dollar issue involved for you or your family, where it's going to benefit you and your family, you just have to declare it. Utah's a declaring state. It doesn't mean you don't have to do anything about it. In fact, I've seen the legislature, great example, one of the guys said, I've just been hired by the company down south to help with this nuclear plant that they're trying to put together, but I'm going to vote on this bill anyway, because it will make me millions of dollars, essentially. What sense is there in that? I have no idea. But the divine light on the hill has said that that's all we need, is just to declare it. You don't have to do anything more than that. As far as I'm concerned, I think a good rule of thumb is avoid the very appearance. If you've got a conflict of any sort where you get a benefit as a result of the decisions you're making or the business that you're running, step down off the dais, go into the back room, let the planning commission or city council make the decision on the application. Now, I'm going to tell you that planning commission, you guys live in the city. There's almost no zone change that you won't have at least something to do with that won't affect your property somehow if it's in your area, right? So, no, don't exclude yourself unless it's a specific benefit to you and your family. You're going to have general benefits as a result of what you do. That's a given. But Clint, if they're approving a new lifetime product or a lifetime product superstore or something, you're going to want to step down, right? That's the most obvious. But if they're, to Zach's point, he had a neighborhood, a subdivision that was being approved. It was his subdivision, right, where they were building the home. And right next to it, you had an application for somebody that wanted a commercial use right next to it.
M1.
Right. Wanted to go heavy manufacturing. Would that have made a difference to Clint? Probably. But I got to tell you, or to Zach, not Clint. Clint's already got his store. To Zach.
Zach just wants a home.
So let me tell you the difference, though. Zach chose to step down on that one. He did. And that was a rule of thumb thing. because did Zach have to step down for a zone change next door? There wasn't a direct pecuniary benefit to Zach in making that determination. He may have had his reasons, but he's still gonna have to come up with zoning reasons, right? Either to deny the commercial use or not. And so there wasn't a direct conflict there, but he chose to take the higher road, rule of thumb. Didn't participate in the vote. And I think that's the kind of thing we need to look at. Yes,
So you
Jeremy.
keyed in on direct pecuniary benefit.
Yeah.
So if I am an employee of an organization that is doing business or doing something in Layton, and I don't actually benefit from whether or not the city grants them what they want, am I still recusing myself, or can I participate in it?
So the closer it gets to you, the more the need to declare that. So when these guys are paying a paycheck and they're also doing business with the city,
Okay.
I think that's probably pretty direct on you. So you'd have to declare.
Yeah,
Okay,
Yeah, you
declare.
don't have to recuse, just
Yeah,
declare.
Just declare.
okay.
Yeah, so, and whether or not you recuse yourself and step down is up to you. And you guys have always done the right thing, so I don't worry too much. Very last thing, I'm sorry, we could talk about some fun stuff, but we're
It's okay,
down
you're
in
covering
the
the ground we need to.
Alex, if I take like 8 to 10 minutes, and this last part is sexual harassment, and I think it's important. It's very extremely important because you've seen the big settlements lately. And what I'm going to do is I'm just going to play through some videos for you. They're 1-minute little clips, and I think they do a really good job of just kind of explaining the city's philosophy on sexual harassment, which there's a no tolerance policy in the city for sexual harassment. And I've seen people walk down the road because of something they put on somebody else's computer, or somebody's copied something and put it on somebody's desk as a joke, or somebody's told a dirty joke, and it was very uncomfortable. And those types of things have come up, and there's no tolerance in the city for that. And so there's a culture here of not accepting the demeaning of somebody based on sex, race, religion. There's a policy of that in the city, and I think that culture is what's important. That's more important than my telling you that sexual harassment involves quid pro quo. In other words, when Weinstein goes to somebody and says, "I'll get you into this movie if you have sex with me," that's a clear case of sexual harassment, and I don't need to teach you that. But the more subtle and insidious is the kind where you cancel out the other person by excluding them from things. Walk into a room, one female at the table, bunch of males. Bettina, would you take minutes of this meeting, please? Well, why me? Why me? Am I really good at taking minutes or something? You know, the answer is no. Sometimes we do that. I'm doing it unconsciously. It doesn't mean every time I ask Bettina to take minutes, by the way, that I'm meaning to be rude or diminish that. But you know when it happens. And so I'm just going to go through some real quick clips. And I hope this is helpful to you. Okay, we can keep, let's see. Okay.
That's the last.
That's the last one.
topic.
Sorry, I clicked over that. Let's go to the next. Okay, and can you hit the link? And some of you may have seen these before, some of you may not have. But I really like this series because it's based less on the old standard sexual harassment. You know, if you tell a dirty joke right next to that, it's more than that. It's saying that you can't have a culture in your city of demeaning somebody as a result of their race, their religion, their sex, their sexual orientation now. In fact, one of the biggest payments that was made in the last several years, I've told you about it, I think, was West Jordan paid a police officer in a sexual harassment claim. The first time they paid him $82,000, Alex. Can't remember. And then he came back to work, and they went after him again.
Retaliation.
And so when they went after him again, it cost him $2 million. So the total cost of that sexual harassment and retaliation was $2.8 million. So, or $2,080,000. Okay, all right. Let's just go through these real quick and we'll get to the end of it here.
Sorry.
I'm just going to go through a couple. Did it come up?
Yeah,
Okay.
I had it over there a second ago.
Just while you're waiting,
Mm-hmm.
you need to change not your tie.
Oh, okay.
Your tie's ugly, but it says sexual harassment best practices. That doesn't make sense.
Okay. I got it. It's to Trevor's point.
Yeah.
You made that point earlier. He says, am I coming tonight to find out how to or how not to? So,
Yeah.
okay, let's go down below. There's a whole bunch of videos.
What we after?
So let's go, hang on just a second here. Okay, next one. Okay, let's hit that one there.
Okay, I gotta figure out how to turn the volume up.
By the way, my favorite saying is, there's a nut on every council or every commission. And if you don't know who it is, it's you. Right? Dave? I'm joking. Dave's one of the best nuts I've ever met. So. He keeps us laughing. So. All right, and then down to the start on the right hand side. So. Oh yeah, the volume.
Yeah, I should have turned the volume up on the TV.
So this is just telling you about Bill O'Reilly, who settled for $32 million, and then the Department of Justice, who settled another suit as a result of jailers who were sexually harassing for $20 million. And then there are over 12,000 cases a year. And this was before the Me Too movement. So you can only imagine how many there are today as a result of it, because people are beginning to understand exactly what it is. And if he were speaking, he would say,
I
it's a
apologize.
lot more pervasive than what you think. Okay.
Yeah, the computer's all the way up. It's the TV.
So we don't have any volume? Okay, that's
I know,
okay.
You're right.
Just waiting.
We're just gonna get plastered.
Yeah, I'm trying to figure out
Hold your
why it's
ears.
not coming on.
Well, let's just do
Was
this.
there a volume on the bottom over here? Oh, you got the remote. Hey, he's got the remote.
Are you thinking you can?
I don't think there's anything on the side of it.
I don't think they still put buttons on TV.
I know, right?
Mason, you're telling everybody how old your TVs are.
It is pretty old. Back bottom corner. On the back side. Either side of those.
Let's just go over some things,
Anyways.
because we gotta get on to other issues and we gotta move forward, but the bottom line in this series of videos is, the very first thing that ought to be known in every organization is that you can report it. And there's a real fear that people have when it comes to sexual harassment of categorizing people as a victim or as a perpetrator, right? But if you understand that many times the victim doesn't understand that they've been victimized. In fact, they had a study where they polled, I can't remember how many women, but a large number of women, and asked how many had been sexually harassed. And about 50% of them said that they had experienced some form of sexual harassment. But another 16% of them identified all of the things that had happened to them, not thinking they were sexual harassment. Jokes in the workplace about their something sexual about them, something about their sex. That was not considered by that 16% as being sexually harassing. In other words, sometimes they take it for granted that that may just be the way businesses are, which is wrong, right? And then the second thing was that the perpetrator often doesn't know that they're sexually harassing. So one of the main things, in fact, when you bring it to the attention of some, they're embarrassed by it. There are others that are offended by the fact that you brought it up. But in all organizations, it's intended that the organization be open enough that you can bring those situations up and get them corrected quickly before they get out of control. Does sexual harassment apply to people who are outside of the city as well? That's one of the questions I had. You're a planning commissioner, and you got a developer who makes comments. You know, that planning commission member, because she's female, does this or that or the other one. Or rarely, but sometimes, a female developer who might say, oh man, boring bunch of idiots, you know. No, that's probably okay. It's the other one that's not right, okay? That's probably okay. But the bottom line is, you gotta watch for this and make sure that a culture of abuse or of discomfort is not created by what you've got existing in the city. And I think we do a pretty darn good job. You've also got to know where you can go immediately if you've got a complaint. Because the faster you get to it, the less you pay. As an attorney, that's a real big concern for me. Because the second biggest thing you pay for, first is land use, second is sexual harassment. Those are the two biggest lawsuits that cities, the biggest payouts that the insurance companies pay are those two things. So it's the reason we train you. I think I'm done, just because we've got to get on with things, but they're so darn good. They really are. They're better than me. I can promise you that. So
they're not overly good.
no, no, Dave, they're not overly good. Thanks.
Gary,
Yes.
to answer your question though, people doing business with the city would be held to the same standard because they're doing business with the city, correct?
Yes, I'm sorry, I didn't answer the question, but yes, thank you, Bettina, that's right. So somebody from outside harassing your people inside, surf and swim's a good example. We get a lot of that type of thing, especially because of the atmosphere, right? It's a pool, you got swimsuits, you got all the other things. That's where we get a lot of that stuff going on, and yes.
And I understand that you're an attorney, so you're thinking about the money, of course. I would suggest that a really good reason for stopping things right away is silly stop.
Yes.
So people don't have to go through that experience.
Yes. Yeah, absolutely. Yeah, I apologize if I led you to believe the money is more important than stopping the culture, because stopping that culture is really, really important. And we've had situations where we've had people very high up in the organization that need to be reminded of that. And even had in another city in another life, we had a mayor that actually stepped down as a result of the things that he'd done to staff, just the comments he'd made, the demeaning attitude. It was bullying is what it was, but he wasn't bullying because they were all male. He was bullying because they were all female. And it became really apparent that we needed to have him in. We had a conversation and said, as soon as this, becomes known by everybody, and it will, because these ladies have been adversely affected by what you did, you're gonna have to leave. And he did.
It works both ways.
Yeah.
Not just from the city employee being harassed, but the city employee harassing someone that's not of the city.
Yeah. Yeah, that happens as well.
And you're putting a major emphasis on the women being harassed, but it's a reverse role as well. They can go either way, which we all know that.
Yeah, the guy in West Jordan was a male. He was harassed, so it goes both ways. Really serious subject. I wish we had more time to talk about it, but I'll send you out those videos and you can look at those, and I think they're really good. And that's it. I took more time than I should possibly about that, but
Well, thank you,
Thank
Larry,
you.
and we do appreciate everyone here that was willing to attend the training, because this is a big deal to us. And I know if any of you guys read the mission statement, core values on the website or on several walls throughout this building, it's really what we want to stand for. You guys have all done that, and we appreciate it, so let's just keep it going forward. We do need to get moving on. We have a major presentation here that's a great presentation that we've got a guest with us here regarding, are you good? Oh, okay. Regarding the Hill Air Force Base Compatible Use Plan. And I know Lon has worked major hours on this thing, but that's with the
Yes.
assist and guidance of Mr. Patrick Small, so I'll let you introduce him. And
For me, this process is 3.5 years in the making. Patrick's been on the process for 2 years, a little over 2 years now. He's with Matrix Design, and he's here to give you an overview of basically what came out of the plan process. There were a lot of people involved. I'll provide more detail with the resolutions in the meeting. But for now, we'll hear Patrick, and he'll answer any questions after he goes through this. So we'll have a few minutes for him. You can choose the wheel that you can actually sit.
Do you have a preference if I sit or stand?
your choice.
I'm gonna sit. That's more informal. Lon told me that I have a strict time budget, so I'm going to stick to that as much as possible. Before I get started, thank you. I want to congratulate Councilmember Edmondson and Councilmember Roberts on your new positions with the City Council, and really appreciate the opportunity to come and present and speak to you all tonight about this initiative that's been going on for a number of years. We're at the tail end of the plan development, and now we've got the real hard work ahead of us, which is the implementation. So I am going to go through some of this information fairly concisely so that we can focus on some of the core issues for Layton City. So you all know that Layton City is the project sponsor. I'm with Matrix Design Group. We've done about 100 compatible use plans for installations around the country that have similar situations, weapon systems, air operations and ranges around the country. So we bring best practices, and we're really facilitators of the process. We did not develop this plan for Hill Air Force Base and the surrounding communities. We merely facilitated the process with the different stakeholders that were involved. So what I'm going to do is give a little bit of an overview of the plan and the process, and really focus on the compatibility issues and strategies that were developed, and then kind of segue into the next steps. As I go through the presentation, please feel free to stop me as I go along. With any questions or comments, we don't have to leave them to the end. I know that we're somewhat time constrained, so please feel free. So what is the Compatible Use Plan? It is funded by the Department of Defense Office of Local Development Community Cooperation, kind of an awkward name, with the local assistance from the participating communities that surround a military installation. So it's principally funded by the Department of Defense, which is the military representing, but it's really driven by the communities. So it's intended to be a balanced process. I believe if you haven't received hard copies already, the plan itself is about 372 pages. It's fairly voluminous. The real core portion of it is the tail end of the implementation plan that has the strategies that came out of the process. But it's really a body of information to help you as elected officials make more informed decisions relative to impacts on the installation, as much as it is for the installation to understand what's happening in all the surrounding communities, and the changes that are going on in aspirations, and how that both can impact the military and how military operations can impact your community as well. Most importantly, it's not a regulatory document, so it's not legally binding, and the recommendations that come out of it are not enforceable actions. So they're simply recommendations that have been worked through the process for the different stakeholders to implement through the process. A little couple of factoids here. Why is it important? Well, Hill Air Force Base is the 6th largest employer in the state of Utah. That $3.7 billion of economic impact is now $4.5 billion, so it has increased. That's a significant value to the region and to the state. And there are a number of active duty and civilian defense contractors that also work for Hill Air Force Base. These are people that live in your community. They make contributions. The things that happen at the installation impact their quality of life as residents in the city as well. Really, the principal benefits of the project is to help maintain the quality of life for the citizens that live in the city, protect the public health, safety, and welfare, while maintaining opportunities for economic development. And for Hill Air Force Base, it's really about protecting the health, safety, and welfare of those who are employed at the installation so that they can continue to contribute to the national strategic protection and military objectives that they have. The project study area, there are 3 parts of Hill Air Force Base. There's the Air Force Base proper, which you're probably all familiar with since you probably all experienced the sound from the aircraft. But there's also the Little Mountain Test Facility up in Weber County, and then out in western Utah, the Utah Test and Training Range is also part of the Air Force Base mission. So what we looked at through this process is the impacts and relationship of all 3 facilities to the surrounding jurisdictions. And then in addition to Layton City, I wish I could move there was, oh, there we go. There's a number of other cities that participated in the process in addition to Davis County and Weber County as well. Layton City is the project sponsor. There were 2 committees that were instrumental in guiding and shaping the plan. One is the policy committee. That was a high-level committee of elected officials. Mayor Petro participated instrumentally in that, as well as military leadership, and really looking from a high-level perspective of making sure that the recommendations that came out of the plan process were appropriate and relevant. And then there was another committee, the advisory committee, which Lon and Chad participated in. This is really subject matter experts who understand the local planning framework, how things work in the communities. And then we also had the public who participated in the process as well. So we had informational brochures, we conducted public forums, we got public feedback both through our project website and via email. So we tried to create as transparent a process as possible. And then we did have a public draft of the plan that we provided access to the public for comment on as well. And some of that public comment was really instrumental in developing some of the recommendations and addressing some of the solutions. So the process had a number of key steps. We kind of characterized these as discovery phase, doing stakeholder interviews, gathering information, making sure the information that we're providing is accurately characterized and comprehensive, doing an assessment of all the issues that were identified and developing the strategies as part of that process that culminated in the plan that is the product of the process. So that's what we did over the 2-year span. So when we talk about compatibility issues, we look at 25 different factors. So we're approaching this very comprehensively. Some of the things are tangible, things like noise. Some things are probably less tangible, like frequency and dust and smoke and steam. But what we have up here are, we categorize them or organize them into social factors, resource factors, and development factors. So those are the 25. There were 18 factors that had issues associated with them. So these bold sets of factors are the ones that were identified through the project to have relevancy to Hill Air Force Base in this compatible use plan. These numbers next to each of these compatibility factors reflect the number of issues that were identified for that particular factor. So what you can see from our process is that there were a lot of communication coordination issues that were identified. There were some land and airspace competition issues that were identified specifically because you've got Auckland-Hinkley Airport, you've got Hill, and you've got shared airspace with SLC. Some water quality quantity issues, particularly related not only to the long-term provision of water, but also some of the contamination issues with PFAS, that firefighting foam that's used, and the experience with that infiltrating into the groundwater and remediation efforts that the base is taking. And then you see a smattering of other types of issues for these compatibility factors as well. So there was a pretty comprehensive set of issues. And in terms of the strategies that came out of the process, there's really 6 of them. The 4 on the left-hand side are kind of the easier types of strategies to implement. The first and foremost, the plan itself is a body of information, sharing the right level of information, and then even looking at partnerships. So partnerships with military and communities. Communities and the military tend to be fairly cost restrained. And so identifying opportunities where there's synergies to share resources to reach common goals that benefit both parties is also part of that set of solutions. And then on the right-hand side, we have policies and regulations. Those are really kind of last resort things. Policies in terms of acknowledging Hill Air Force Base in general plans, regulations in terms of looking at land use and zoning. The attorney who spoke before me talked about cost implications for litigation. One of the key components of compatibility is making sure that private property rights are protected through the process. The last thing that we want to do through this process is put the city any city in a position where there's a takings claim or some litigious impact that comes out of this process. So these are things that I kind of want to touch on when we go through the specific compatibility issues. The strategies were identified through the committee input that we received throughout the process. Also with the public, they've provided some good recommendations as well. And then the expertise that we bring to the process, having conducted a number of these around the country. And so where we arrived at were 110 unique strategies. And the reason that there's 110 strategies for 43 issues is because not every strategy is going to be appropriate for every community. And there may be different ways or different strategies for achieving the same goal that might be more appropriate for one community versus another community. And a good kind of example of that is if a community is impacted in a land use perspective, one community may say, you know what, we're willing to change our zoning code to achieve whatever objective it is that we're trying to achieve. Another community may say, you know, rather than doing something in our code, we're going to do a memorandum of agreement with Hill Air Force Base where we will communicate when development applications come in that might be a concern to the installation so that we can get their input directly and factor that into our decision-making process. So there's not every strategy is going to apply to every jurisdiction. That's going to be dependent on you as the elected officials having that sensitivity to what will work for Layton City. On you as the elected officials having that sensitivity to what will work for Layton City. One of the other key components is making sure that the strategies that are in the plan apply to the appropriate geography. So one of the things we don't want to do is create a scenario where there's overregulation, where there's no impact. And so what we did through the process is we created what we call military compatibility areas. These are the areas where there's those intersects between the military operations out in the community and where those areas are within the communities. So for this plan, we identified 4 military constructions. And the composite of all of those compatibility areas is what we call an overlay district. And it's really a planning tool to help identify where strategies need to be addressed within the geography of a particular city. So in this case, this is the overlay district. In this inset, you can see this is Hill Air Force Base here. This overlay district extends entirely around the installation into the surrounding communities. What I've shown on this particular map is roughly the boundaries of Layton City and where it is relative to these military compatibility areas. And so Layton City is kind of in a unique position because you are within all of the military compatibility areas that were identified through this process. So these strategies are particularly relevant for Layton City and you as the elected officials to contemplate. So one of the things that we looked at is the noise military compatibility area, and on this map we've got the boundary for Layton City, and these noise contours are where the noise is modeled by the Department of Defense. Noise is very subjective. It does not stop at these contour lines. These contour lines are areas where the Department of Defense also has land use recommendations relative to what they call noise sensitive land uses within these contours. One of the things that has come out of the plan process, particularly from the public, is that there are a number of impacted residents in Layton City that have identified deficiencies with these noise contour modeling, that it does not accurately reflect the human experience and that impact on quality of life that they have as residents within this area. So they were instrumental in helping to develop some of these strategies that are up on the left-hand side. There are strategies that Hill Air Force Base can take. There are strategies that the community residents can take, and there are strategies that the city can take as well. One of the key things that I want to point out is the same federal agency or department that funded this plan through the National Defense Authorization Act of 2021 has been charged with creating a new program specifically tailored to noise called the Community Noise Mitigation Program. That is something in recognition of impacts in communities from noise, from aircraft, other types of military activities. And they identified a number of military installations that are targeted for this particular program, and Hill Air Force Base is one of those. The challenge right now is that the program has not been stood up, and the DoD office that's in charge of that program is trying to figure out what that program entails. And there's a congressional set aside of funding for that, but how that funding is allocated, where it's allocated, how to rank which communities get that funding is still up in the air. So we bring this to the attention of the participants in this project, because when that program does get initiated, we want to make sure that you all have awareness and the other communities have awareness so that you can mobilize to take advantage of the program when it does occur. I'm going to jump to safety. So at the ends of the runways are what are called safety zones, and they're created because they're statistically the highest probability areas if an aircraft accident were to occur. These are the areas where that would happen. So they're created by the Department of Defense to provide land use guidance in recognition of uses that encourage congregations of people within these safety zones. So the more people you have, the greater the potential risk if an incident were to occur. For the safety zones and for the noise zones, the DoD has created land use guidance. For the noise zones that were on the previous slide, they recommend exclusions of what they call noise-sensitive land uses, things like schools, residences, hospitals, long-term care facilities, places of worship, things that noise might be more sensitive to. They have guidance and recommendations in terms of those land uses. For safety, they also have recommended land uses as well to reduce the congregations of people within these areas. It's important to note that the land use guidance is simply that. The Department of Defense does not have any authority for private property or over private property. So it's really there to protect the public health, safety, and welfare of the people who live in the community. All right. Bird, wildlife, aircraft, strike hazards are types of activities or uses that encourage birds and wildlife that might have a detrimental impact on military operations. So you don't want a bird having an impact with an aircraft or an aircraft engine. That creates a scenario where, potentially there's impacts on the ground in addition to damage of an aircraft. So on this particular map, this is the boundary for the BASH, as the acronym is. This is a 5 statutory mile boundary essentially from the airfield. It's recommended by the FAA, but it addresses certain types of uses or certain ways that development occurs that encourages birds and wildlife within this area. So things like golf courses, things like landfills, transfer stations, retention basins, open air sewage ponds are things that attract birds and wildlife. Even the types of crops that are grown can attract birds and wildlife. That doesn't mean that you have to exclude those from your community, because there are ways that you can design facilities to discourage bird and wildlife attractants. So if you have a golf course, if you line any water features or water traps with riprap, that would discourage birds and wildlife from being in the community, or being a potential issue for the military. Vertical obstructions. This is an area, it's 3-dimensional space that occurs around the runway. It's an area where structures, both natural, such as trees, or man-made structures or human-made structures, such as communications towers, utility poles, buildings, even temporary construction cranes can potentially be an obstruction to safe pilot navigation. So this is in the Code of Federal Regulations. It applies both to civilian and military airfields. And for military facilities, I'm sorry, I just lost my train of thought. What you have here on this map is the boundary of Layton City relative to these imaginary surfaces. One of the complexities of imaginary surfaces is that some of them are sloped, some of them are plateaued. It's a mathematical process to calculate whether a structure actually impacts those imaginary surfaces. Now I remember what I was going to say. So for structures over 199 feet, they have to automatically go through an FAA process. But structures closer into an installation, such as, you've got the those imaginary surfaces here in in Layton City, structures that are under 199 feet that could be a potential vertical obstruction do not go through any FAA process. So what a lot of communities do is they include that federal Code of Federal regulation language in their regulations, but don't really know what to do with it, because the process for calculating whether something is a vertical obstruction is dependent on the airfield elevation, it's dependent on the elevation at the development site, and it's also dependent on what the specific height is for that imaginary surface at that location as well. So there's some recommendations that have come out of this process. One is developing a three-dimensional imaginary surfaces model. That's a tool that automates that whole process so that the planning staff can evaluate applications easily when they come in, applications that have a vertical development component. And it also helps the development community understand the implications too. If you have a property that is bifurcated by two sets of imaginary surfaces, that single property can have a higher development potential at one end than at another end. So having the public understand what the implications for this are is relevant as well. So those, and I know I ran through it extremely quickly. It doesn't do the 372-page document justice, but it does touch on some of the core issues and some of the strategies that were identified that are particularly relevant to Layton City. In the last few minutes, I want to spend just a little bit of time talking about next steps and implementation. That's really the hard part. And you do have the resolutions to endorse the plan and the participation on the implementation coordination committee. That committee is intended to maintain the momentum of the project through implementation. They're not the executors, they're kind of the facilitators. So they would be responsible for monitoring, identifying any challenges, and how to overcome them. And even as different jurisdictions implement recommendations or strategies for their particular community, there may be lessons learned locally that the other communities can take and implement as well. There are those 110 strategies. Some of those are plans, some of those may be studies, some of those relate to general plan enhancements, zoning code changes or amendments, things of that nature. There is funding from the same federal agency that funded the plan for implementation, because the last thing that the federal government wants to do is put a lot of money, invest a lot of taxpayer money in developing a plan that just sits on a shelf. So they've got a pool of funding to help facilitate implementation and carry that process forward. I've talked a little bit with Lon and Chad about that as well, because Layton City as the project sponsor would be the ideal candidate for facilitating that implementation funding process as well. The caveat to that is when the Office of Local Development Community Cooperation looks at different applications for implementation, what they like to see is some demonstration of commitment from the surrounding jurisdictions that shows a good faith effort that the communities are motivated to address compatibility. And so what we recommend for communities is that there are strategies like the communication coordination strategies don't really have a cost impact. It's a communication impact. Those are low-hanging fruit that jurisdictions can implement early on without having to rely on the implementation process to get started. So those are things that the city can do to help start that implementation process. That's looked favorably upon by the old CC, that funding organization. This is my last presentation I'm doing because under our contract, we offered presentations to other jurisdictions as well, and I've been doing those principally this week. Other communities have also expressed an interest in implementation funding, so I want to make sure that you're all aware of that. And the other jurisdictions have also endorsed the plan as well. In fact, Clinton City has already adopted their resolutions. Davis County is adopting their resolutions this evening. So other communities understand the value of this process and the value of implementation. And
South Weaver's adopted theirs too, haven't
they? They have not yet. But everybody that I've met with has committed to or have it on a future council or commission agenda for adoption. So there is that support for implementation.
It was presented to them on Tuesday.
I can't even remember which day it is. There've been so
This week.
many.
Yeah, I was
Yes.
gonna say, I thought that you presented there.
Yes.
Just naturally assumed it probably.
Some of them have been work sessions because Tuesdays are extremely prominent evenings for council meetings. So
Just like us tonight.
So we weren't able to, so some of them we did work sessions, like Davis County this afternoon, I did a work session with them, but they've got it on their agenda. So I know that doesn't leave you with a lot of time for questions.
We got the expert with us.
You do. So I want to thank you for the opportunity to come and present. I know it was brief, but I
It's a
think
lot of information.
there's some important things that you needed to hear to keep the momentum going, and certainly things that the city needs to consider relative to some of those compatibility areas, the noise and the safety zones as well. But you've got a good shepherd and champion for implementation, and so.
Thank you. And anybody that would like a hard copy, I have one for each one of you on the council. If you'd like one, and the mayor, just let me know. It is available online, and that website will stay up for about a year. Is what they typically do. I don't know.
Unless there's implementation and that website, there is a project website that has all the information and process and whatnot. That typically gets maintained for about a year. If there's implementation, it gets carried further even forward because implementation gets typically gets built into the website as well. So.
And we have it saved locally in case we need to print it off. So.
I was gonna say, yeah, to me, you go to all that effort and you want to be able to have it available electronically for folks to look at. 1 year doesn't do it justice, and even two if we're into the implementation stage, it needs to continue.
So I have a question, if
Sure.
that's okay. So we take this information and that information and lawn and as a city, do we come up with we have master parks plan, we're working on the active transportation plan. Is there Layton City's compatible use plan with Hill Air Force Base with what we feel like we want to take from these findings, create our own plan moving forward and goals? Is that this process, is that what we're grabbing and saying, okay, here's what we're in this Layton City? And
Some of the strategies are unique to Layton City that the city can implement on their own. Some of them are collaborative and require a larger, more regional solution, of which Layton City would participate. So what the next step would be identifying what is relevant to Layton City, identifying the strategies or approaches that Layton City would be amenable to or have the political will, and based on the sensitivity of the recommendations, and that would essentially become Layton City's plan for execution. And certainly in terms of facilitating that implementation funding, looking at what strategies would benefit from that additional funding, because it's not just the plans and studies, it's updating general plans, updating codes, facilitating a public process to do that is all eligible for that funding, so that it wouldn't fall just on Lon and Chad's shoulders to do. And we can help Lon identify what those key strategies would be from our experience doing implementation programs for compatibility plans as well. So
thank you.
Well, Patrick, I really appreciate your time and energy on this and guiding it through the process. Long 3 years, and it's just going to start.
Well, he's done good. He doesn't have the gray hair that I have from.
Okay. Well, thank you. I really appreciate you coming here and presenting.
Thank you.
Looking at our agenda, we still have 2 more items. We've got 6 minutes. Unless we need to make a quick break. So do I only plan on 4 minutes, which means 1 item, a briefing. So Ted, do you want to go ahead and start then?
Sure. We had
I'll
grab on the slides real quick, Weston. We had a discussion about this ordinance previously. This is the ordinance that would change some of our standards related to landscape buffer areas along our trail and collector streets. I think what we could probably do just in this brief period of time is talk about some of the things that were discussed at Planning Commission. They did ask us to come back with a little bit more information. And then we did have some grammatical and typographical errors that have been identified that we will be including in our motion for adoption, or things that are identified by council members as they review the ordinance. That always seems to happen with these large ordinances, and we have a few of those. So with that, I'm going to turn some time over to Weston for just a moment here to talk about some of those just changes, issues that came up with Planning Commission that we've tried to address in this latest version of the ordinance. Should come up. Duplicate screen here. Thank you. And as Weston's pulling this up, I want to recognize his efforts. He was primary author on these changes and done a great job of coordinating this effort. So, thank you.
So as we went through this, we've generally identified the main issues that we've come across with these landscape buffers. Really holistically being them being maintained in the same HOA instead of in a lot of individual homeowners' property and running through an easement. We also see a lot of issues with, I shouldn't say a lot of issues, we see issues with them not being maintained, and so this ordinance really is to just strengthen the current ordinance that we have. So the ordinance that we're looking at is really intended to address buffers that are owned and maintained by HOAs, provide the minor density increase, and we're going to talk about that in just a second, and then strengthen the language related to the CC&Rs, the covenants and restrictions that are recorded for HOAs. And then Lastly, to potentially impose a fee on the landscape buffers that are not maintained. When we looked at this, the point really was to get these landscape buffers holistically in a constant flow of maintenance and taken care of. And so to do that, part of that would be to establish it and say that the landscape buffers are no longer a part of, with some minor caveats, a part of the individual property owner, but now they're associated with the homeowners association. To do that and to provide that trade-off, that comes with a little bit of a trade-off to say for the developer, who's the landowner, to increase the density a small amount as a community benefit, as a trade-off. And what that will do is basically what we're doing here, we already lot average our RS subdivision. And so the amendment is to lot average the other zones that we use in the same format. And so all this really does is this striked out text basically is just populated in a table format, producing the same type of structure for our RS zone in our other single family residential zones. And then this is the general densities that you'd be seeing. So here's the base density, and then here's the increased density. Now this would occur within 300 feet of the arterial or collector roads, just within those areas. So if the subdivision is larger than that, then just that 300 feet, that additional part of the subdivision wouldn't be law average. It would just be within that 300 feet. And then, basically strengthening CC&Rs. So we would be looking for specific language that would come across in the CC&Rs that would make it so Layton City had a stronger tie, that the CC&Rs couldn't be, or excuse me, the homeowners associations couldn't just dissolve themselves, thank you, and that we have a stronger tie in that. The next section really is the last straw. So the intent would be that if we have a landscape buffer that's not being maintained by an HOA, whether that's because the HOA was never formed previous years and years ago, the HOA has gone defunct, or they have just chosen not to maintain it, we would go through the code enforcement process. But this here would be to establish a section that would say, look, this is a difficult situation. We've got 30 homeowners in this landscape buffer area against this subdivision, and we need to maintain this, and enforcement has not got us there. So this would provide us an opportunity for the city to step in and say, we're going to now assess a fee, and that fee will be applied through the utility billing process, and then the city would contract with someone to maintain that landscape. So that's a quick rundown, and it's right at 7 o'clock. So try to go fast.
We're happy to answer additional questions in the regular session, and we'll give a little more explanation on a couple of those items as well. So.
You good? All right. Well, I'd say thank you. I'm sure expect discussion in the next meeting. We are already over 1 minute. Does anybody need to take a quick break, or we good to just go straight in?
1 minute. I need about it.
Okay, we will take a quick minute and then
You're great. I can't wait to watch the videos.
No commercials. Commercial.
I got a special set for you.
Yes,
like to welcome everyone out to our Layton City Council meeting this evening. It's February 17th, 2022. And once again, I apologize for the delay. It seems like each time we get more and more information to cover in our work meeting. And so it's critical that we're able to do that. So for this purpose, we will now open up our council meeting. And as customary, we always do a prayer and a pledge, and each council member takes a turn at this. And so I'm going to turn the time over to Councilmember Roberts.
First of all, if you'd please rise, we'll say the Pledge of Allegiance with me. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Our Heavenly Father, we express gratitude to Thee at this time for the opportunity to gather together here as citizens, as friends, as staff, as leaders of this city. We are grateful for the opportunity we have to live here in this great community. We're grateful for the freedoms that we enjoy and for those who work every day to protect those freedoms. We're grateful for the opportunity to discuss important matters of the city at this time, and we pray that Thou will guide us to make wise decisions and keep in mind the far reaching to each corner of our city which we live in. We pray for these things in the name of Jesus Christ. Amen.
Okay, thank you, Tyson. Okay, council, we do have 3 sets of minutes that we need to approve. Do any of you have any corrections with the minutes that were in your packet? Okay. Seeing that there's no corrections, then I'd look for a motion to adopt the minutes. And if you wouldn't mind, go ahead and read them as they are on our agenda.
I move we adopt the minutes of September 2nd, 2021, October 7th, 2021, and December 16th, 2021.
Well, second.
Okay, it's been moved in second that we adopt the minutes of the meetings. All those in favor, please say aye. Aye. Any opposed? Okay, thank you very much. We'll move on to item number 2, which is our municipal announcements. And I'm sure we've got a few of those, perhaps our Parks and Rep liaison.
Yes, from the Parks and Recreation Department, we have 3 events next month in March. First of all, March 18th is Wear Green at Surf and Swim from 6:45 to 8:45 p.m., half off admission when you wear green. And so that's it for that one. Also on March 18th at the Central Branch Library, there will be a family recreation evening with a readathon, Dr. Seuss's family night, and other fun activities. So cost is free. So bring your family 6:30 p.m. to 8:30 p.m. at the library. And April 11th, there will be an Easter egg dive and game night. It's going to be from 6:45 to 8:45 p.m. at Surf and Swim also. Cost is $2 per child under 14.
Good. Sounds like we got some fun events happening again. Does anyone else have any announcements? I'll just once again promote our museum. We have a great display over there right now. Annie, our curator, has a extensive collection of William Allen's design, who is a major home builder here in the early settlement of our city. She's got a lot of the architectural plans, some of the ledgers and that, and it's really kind of an interesting display. So if you want to spend just half hour, 40 minutes, it's a great display to look at, as well as other things in that museum. So again, hats off to Annie and the commission and the committee over there that helps her. Okay, we'll move on then to, we do not have any verbal petitions. So we'll go ahead and move on to our citizens' comment at this time. So if any of you in the audience wish to make a comment before us that on an item that is not on the agenda, now keep in mind our consent items, typically we do not take public comment on. However, we do have a public hearing. So if your item is under that public hearing, we will allow you to speak at that time. So anything else, you're welcome to come up to the podium and please state your name and address for the record.
Good evening, esteemed Mayor, City Council, and the entire Layton support team. My name is William Campbell, and first I just wanted to thank you. My family's been blessed by all the great things that the community has put forth, and I'm now in the process of looking as a chance to return the good favors and make the community better. I will be running for political office this year, and I just wanted to declare my intentions in case you see me in the streets or happen to cross paths. Thank you.
Okay, thank you and good luck. Does anyone else have any comments?
Tom Tudor, 1757 Gregory, Layton, Utah, 84041, for the people. I just want to say this a couple of words because I've been watching the Russians, the Americans, the Germans, the Poland, and everybody, because I was in the military for 20 years, 20. And I was even in Germany when we had the Berlin Wall. And Ronald Reagan came over there and told him what to do. So now I just want to credit the 419 TAC Fighter Wing of Hill Air Force Base. And then you have the 508. And they have already left over there, flying over my houses. And I was glad to see that. But our first squadron is over in Germany right now, preparing for the war. And I prepared my wife and children and everything and gave them some history lessons while all this is going on. Because I was alive when we had the Vietnam War. And I don't want to see this all messed up. Let's go from A to Z and be done with it. And I just wanted to say anybody that's in here that's been in the military, then I personally thank you, and I'm sure the mayor and the city council thank you too, because the next week is going to be different than this week. And thank you very much.
Okay, thank you, Mr. Tudor. Okay, anyone else wish to speak on an item not on the agenda? Okay, very good. We'll go ahead and move on then, and we appreciate those in attendance tonight. We've got several consent items here, and as you know, these items are presented, and as the governing body here within the city, we can actually act upon these items in one single motion unless one of them is removed for some reason. So I haven't heard of any discussion to remove any items, so I'm just going to go ahead and proceed in order. We'll start out first off with item number 8, and our city attorney, Gary Crane's going to present that for us.
Thank you, Mayor, members of the council. Let me just move this down here. So item A on the agenda is the appointment of the Utah Telecommunications Open Infrastructure Agency, which is Utopia. To that board, it is an appointment of Zach Bloxham. Okay. And previously it was held by Clint Morris, and it's time for circulating that back through again. So resolution 22-10 is your the mayor's advice, or it's the mayor's appointment and the advice and consent of the council is what it provides for.
Okay.
Thank you.
We appreciate that, Clint. We appreciate your service on that. And I think it's good to just kind of mix it up. And so everybody gets a chance to learn on different topics. So Zach, thank you.
Am I allowed to, should I vote on this or should I abstain?
You can vote.
Okay. That was part of our previous meeting on our training.
unless you're being paid a lot of money.
Try it.
I don't know how that goes.
It won't do you any good, but you can vote.
Yeah. Okay. All right. Well, thank you. We'll go ahead and move on then to our next item, which is item B. And Mr. Dave Price is going to present that item to us. It's regarding the Parks and Rec Commission.
Thank you, Mayor. This evening, I have the pleasure of introducing Resolution 2208. If approved, this resolution will reappoint the existing members of the Parks and Recreation Commission for an additional 3-year term. Mayor Joy Petrel recommends the reappointment of C.J. Benson, Angela Richards, and Michael Scott Quinney as members of the Parks and Recreation Commission with the term ending February 1st, 2025. Staff recommends the council adopt Resolution 2208, reappointing these individuals as members of the Parks and Recreation Commission. And I'd personally like to thank all of the members of the commission for the time and energy they choose to spend helping our department, city, and the residents of Layton. Any questions?
Council? Okay, I appreciate that. And these folks do a tremendous job for us. And I know that they spend a lot of time that is on their own time, not necessarily in just the monthly meetings, but we call upon them to help us on a lot of different events that take place throughout the city. So yeah, my hat's off to all of them, as well as anybody else on the other commissions as well. We desperately and sincerely appreciate their service. So thank you, Mr. Price.
Thank you.
Okay, we'll move on to item number C, and Mr. Chad Wilkinson is going to present that item. It is regarding our Planning Commission.
Thank you, Mayor, Council. This is a proposed appointment to the Planning Commission. We, of course, with Councilmember Roberts' recent election to the City Council, there's a vacancy that's arisen in our Planning Commission. The Planning Division, along with the mayor and a committee composed of some of our City Council and current planning commissioners, met with some great applicants. We had 4 of those applicants that we met with individually, and each of them were very, very qualified. We were very impressed with the folks that applied. Always a difficult decision to have to make in those cases. After those meetings and consultation with the committee, the mayor is proposing that our existing planning commissioner, Chris Crowder, be appointed as a commission member. He is currently serving as an alternate commission member, so he would leave and serve as a full commission member. And then that alternate vacancy would be filled by Scott Carter. And many of you are familiar with Scott Carter, who served in various capacities in the city as well as in the City Council recently. So with that is the mayor's recommendation. And this particular appointment requires the advice and consent of the City Council, but we are, along with the mayor, recommending approval of Chris Crowder as as a full member of the Planning Commission, and Scott Carter as an alternate member of the Planning Commission.
Anyone have any discussion?
So when these are seated, do they start over at a full 3 years when we seat a new planning commissioner?
Thanks. That's a great question. No, these will be fulfilling terms. So there are terms that are set. These particular individuals will be fulfilling terms. Sometimes those terms are in our code. It specifies that if someone's fulfilling a less than 1 year term, then they're eligible for a full additional 3 terms. If they're fulfilling a term that's more than a year, though, they'd just be eligible for that term plus 2 more.
Okay. I've had this question before, but I've never asked it, and maybe I don't know if it's our bylaws for our planning commission, but I understand that when it's an elected office that it needs to be up for re-election when the term ends, but where it's an appointed, is it an option that we could give the person an opportunity to serve the full 3 years where do we need to have those refilled every 3 years?
One of the challenges that we have, just as with the elected positions, is that those positions need to be staggered so that we don't have all of those positions needing to be renewed at the same time. So because of that, it is difficult to give everyone a full 3 years. However, again, you're considered to have served a full term if you serve more than 1 year. So those that are filling terms that are less than a year would be eligible for that full three terms.
Good question. Anyone else? Okay, thank you, but remain standing. We got a few items here that Chad's going to cover for us, which item number D, which is a plat amendments or amended plat. So do you want to go ahead and present that to us?
Thank you. Yes, this first, again, Council and Mayor, this first application is an amendment to a subdivision. This is the Indian Springs Creek subdivision. The subject property is shown there in red. The two properties are located at 1329 East Indian Springs and 161 South Indian Springs Drive. This is the property shown outlined in red. Currently, this property is made up of two distinct lots. There's a property line, I'll show you that in just a moment, that goes about right through there. These lots are double fronting lots, one of them even a triple fronting lot that front on Indian Springs Circle, Indian Springs Drive, and Rosewood. The proposal would be to take those two lots that currently exist and create three. So you'd have one additional new lot from those two. This is a copy of the existing plat. I'm outlining one of those two lots with my cursor. The other is here. Again, those two lots currently straddle the creek that exists there in that location. And the proposal would be to modify that to create an additional lot to the north of that creek along Rosewood Lane. This is the proposed configuration of those proposed lots. Anytime we have a flood zone or those types of creek areas within these lots, we do require the creation of a restricted lot, which that R designation shows on the plat, and gives some restrictions for those lots related to the development on those parcels. One thing that was very important to us is to make sure that this was actually a buildable parcel that we were creating. So the applicant has shown that, demonstrated that through a drawing that shows the type of house that could be built, meeting all the setbacks, including setbacks from the Davis County flood control easements and the flood zones and the various public utility easements. This is just the elevation of what that proposed home could look like on that site. Again, this is an issue related to floodplain. We had some question about the floodplain. The floodplain maps have changed. These various dotted areas and crosshatch areas represent the various areas of the flood plains. The real question here is this floodway. That's where the most, I guess, the highest chance for flood occurs. Areas outside of that are included in the flood zone, but are areas that can be built on with proper flood proofing and elevation certification. So with that, we have reviewed this with the Planning Commission as well. They send the recommendation of approval, and we are also recommending that the City Council approve this proposed subdivision amendment. Be happy to answer any questions if I can.
So Chad, that the floodplain, or I guess it's the 100-year flood plan, was just recently reviewed and updated. So this map here reflects that, right?
Yeah, this last one that I showed reflects that. And again, it's the significant change here is that floodway, which is that highest percent chance of flood. That's got some very strict regulations. But these flood plain areas, they're known as Zone A's. They're areas that are still prone to flooding, but that can be mitigated through construction techniques and through elevation certification of the structure.
Okay, thank you. Council, do you have any questions regarding this?
You said they can be built on with certain actions to make it safe. Can you explain what those are? And background, I'm familiar with property on Kays Creek, and can you go back to that floodplain? That one right there. So where it kind of balloons up, that reminds me of certain areas on Kays Creek where that has washed away. And so I'm a little concerned about building a home that close to the floodplain area, but can you explain what kind of work is done to prevent that?
Yeah, the certification requirements require that the first floor area be elevated a foot above that base flood elevation. So they're going to have to do that to begin with. Those areas that are within those floodplains, for areas that are not habitable, not finished floor area, you can have things like louvers, other things that can be done. I don't know exactly what would have to be done on this particular parcel. That's going to be part of their their development approval. But those are the types of things that can be done to mitigate some of those flood impacts. In this case, it could be just as simple as elevating it above that base flood elevation.
I guess my concern isn't flood as much as erosion and the ground being washed away. So is there precautions that have to be made to shore up the sides of the creek?
If that's an issue in that particular area, it comes down to what the creek's doing in the area. Sometimes you'll have a place where a creek is making a sharp bend, and those velocities and the potential for wash away is higher than in an area where a creek's just going in a straight line. So as part of their development of the parcel, they'll have to show us that they can safely build there, and the proper elevation certifications and any floodproofing techniques they have to do.
Any other questions here? Okay, typically we don't take comments from the public on a consent item. I kind of stated that before the meeting. However, however, I don't want to disregard your comments, so I'll entertain one here if you'd want to step up to the mic and ask your question.
Yes, my name is Mr. McNair. I live at 1329 Indian Springs Circle, and I've lived there for about 25 years, and there is a flood problem. That creek might come down like this, but it comes across and washes out the property on the side they want to build in. Our main concern, myself and my neighbor, is if they're going to put in a retaining wall big enough to keep the water going down through the flood channel, because in the notch that showed up on the top there, that's where it all washed out. It's all real low, okay? He tried, the people wanted to go ahead and build a building or a house on it years and years ago, and the city turned them down, okay? All this time, this fella that owns the land owns that whole thing as one plot of land. I only own out to the center of the creek, and the neighbor next door only owns out to the center of the creek. So it's actually already 3 lots. He held that part back for all these years. If we have a concern that if it is a house built in there, that it's a single level, it does have a floodplain. It'll have a basement would flood easily in that area. And that's why they put in the big culvert type thing. So that's our main concern, is it's, that they'll have enough secure land to go ahead and build on first off and keep the water going down without washing it out. Because we have had some severe floods through there in times.
Okay.
So that's our main concern. We don't care about the property being in another piece of property. It's the idea of what's going to be built there and if it's going to be safe and be good enough for the creek so it doesn't go ahead and wash out and give the person that might be in that house concerns, or the city concerns. Because the city has come out there a few times just to clean out all the stuff that came down through creek, just so the thing wouldn't flood out anymore.
Okay.
So that's all I have to say.
Well, thank you.
Thank you.
Thank you very much.
If I could just really quickly address maybe some of those concerns. On the plat map, if I can go back to that plat map, this large swath of ground through the middle of those properties is a Davis County flood control easement. That'll still be in place. That'll still be enforced. The home will have to be built outside of that. That's centered on the creek. It's a large swath of ground, gives the ability to go in and maintain the property should there be a flood event. That's likely where the highest likelihood of flooding would occur should there be a flood in that area. These maps that we showed you are a little bit, the scale of these, it's a little bit hard to tell those buildable areas. But if you look at that, again, that flood control easement, your creek's going to be essentially centered within those easements, and give plenty of room for vehicles, for maintenance equipment, et cetera, to get inside of there. As we noted, they will have to meet flood-proof standards to build this. That's wise on their part. It's a requirement as well. They're going to have to meet base flood elevation height that is identified in the engineering memos for this particular lot. They'll have to have a finished floor elevation that's indicated by our engineering division. That'll have to be noted on the plat. That'll have to be approved and shown that it meets that base flood elevation requirement. And so because of those changes, the recent changes in the floodplain, our engineering department did feel that this was a lot that could have a buildable area on it now, and that could go through those processes to refine and get to that point where we could approve it.
Thank you.
If they build what they need to build to stop it, what happens to the guy next to them?
all of that's going to have to be.
Going to funnel everything through, which is fine, and you're protecting that land, then when you get to Bob's place next to it, is that going to?
So there are standards in place that protect from that type of a damage to an adjacent property.
Okay.
They're going to have to show that what they're doing does not raise the flood on the adjacent properties, the flood potential.
Yeah.
So all of that's in existing regulations. They're not discretionary. They're administrative standards that have specific requirements in order for them to build on that lot that ensure that the actions that they take, they're going to have to be reviewed by our engineering department, their own engineers, to make sure they don't negatively impact those adjacent properties. Yeah.
Good.
Okay. Hey, Chad, I just have one question. Just for clarity, the two lots that are current, you can go back to the picture that shows what's currently there. These two lots are currently owned by the same person, correct?
They're owned. I'm trying to remember on this one. We have two different amendments. I think this is the one that's owned by the same individual. Let me just double check that on our staff report. Yes, the same individual owns both of those lots.
Okay, so, and what we would be voting on today is for these to be split, not for anything else to be happening. As you've already mentioned, if anything's going to be built, all that is separate because that's development. This is to separate the lots.
Yeah, so it would be taking this property, going back to this picture, taking these two and making a third back here. So you'd have 1, 2, 3, as is shown on that plat. 1, 2, 3. Yep, that's right.
Okay, so separating from 2 into 3, that's it. Anything that has to happen after that development, that is a whole separate process.
Try to be subject to local, state, and federal law. Yep.
Great,
Yep.
thank you.
Just one question, Madam Mayor, if I may. Gary, is this an administrative decision? It doesn't really have a lot of discretion for us.
It is. It's a subdivision approval, so yes.
Okay. So the staff's recommending it because they've met the requirements that are required by law. And we're not guaranteeing that the home will be built. All we're doing is they've dotted the T's and, right, dotted the I's, crossed the T's, and they'll have to do that sooner or later. So I appreciate the comments from the neighbors who've lived there because I think that's important. But you know, if they've met all the requirements, then we don't have a lot of discretion, but it's going to be on them to make sure it's built to the proper way so that it can be a place of habitation. So I appreciate your comments, sir.
Okay, we good? Okay, let's go ahead and move on. You have one more item yet to present to us. So if you want to...
The next item is also a subdivision amendment. In this case, where it's essentially a property line adjustment because this crosses two different subdivision boundaries. We are here looking at this. The two subdivisions we're talking about are Willow Cove Estates Phase 2 and Whispering Willow Estates Phase 4. This again is the location there on the map with the red dot showing that location. Here's a zoning map showing that property outlined in red with the cross hatching. These are two lots again shown here in red. I want to show just the adjustment very quickly. So this is the northernmost of those two parcels. This adjustment would take the property line that runs approximately right here now and bump it to this location. It's a fairly small adjustment. Same thing would happen in the inverse on this side, bumping that property line down. The primary purpose for this amendment, these are two maps that show the existing lots in the subdivisions that they exist in. But the primary purpose of this, if I can go back to this, is, and it's a little bit difficult to see on this particular map, but if you look at the way the property line runs, it comes up into this property, and if there was to be a future fence built along this property line, it would be a difficult thing. It would essentially put a fence in front of this person's home. So the idea is to adjust that property line so that future fence, probably you can see it a little bit better here. If you were to run that fence, that fence would essentially run in front of this home. The desire of the property owner is to adjust that so that a future fence would not come up in front of the home, but would just run along the side property line of their neighbor. And so this, again, is essentially a property line adjustment. It does go through this amendment process because these are on two separate subdivision plats. This has been reviewed by staff and by the Planning Commission, and both recommend approval of this. I'd be happy to answer any questions if I can.
Any questions, council?
So Bob, on the bottom, He's okay with this?
Yep.
Okay.
Yep. Both of these are co-applicants in this. Yep. A lot of Bobs.
I think this is a good example how neighbors can resolve their own problems, which is kind of good. So I commend the neighbors there for working this out. Any other questions? Okay, very good.
Thank you.
So you are finished, and now we get to hear from Mr. Long Crowell, sorry, on the compatible use plan. So, come on.
Thank you, Mayor and Council. Let me get this up. I'm here to present tonight to you Resolution 2216 and 2217. 2216 is a resolution to accept the Hill Air Force Base compatible use plan and endorse the implementation strategies identified in the plan. And Resolution 2217 is a resolution endorsing the formation of the Hill Air Force Base Compatible Use Implementation and Coordination Committee. These are tied together, so I'll present them as one item. And I'll basically be giving you a brief history. It's hard to see the screen with the flag in the way up there, but you can see this has been quite a journey. This started in the spring of 2018 when the former mayor, Bob Stevenson, and former community development director, Bill Wright, and I met with Jay Sweat. Jay Sweat is a representative from what is now the Office of Local Defense Community Cooperation and was previously the Office of Economic Adjustment. And he explained to us the opportunity to obtain a grant for the compatible use plan. A compatible use plan, the purpose of a compatible use plan is to identify the conflicts between the base mission and its surrounding communities and come up with strategies to mitigate those conflicts so we can ensure the longevity of the base. Following that, in July of 2018, the City Council passed Resolution 1850, supporting the application towards that grant. It took some time to coordinate with all of those involved, which I will be showing you the next couple slides. And we were able to hold a meeting in October with the elected officials of, at the time, 10 cities and 2 counties, along with some city managers and their staff. And they overwhelmingly decided to move forward in that meeting after it was presented to them by Jay Sweat at that time. We went through a process. I formed some committees, volunteers from the participants, the surrounding committees, and together an RFP and a scope. The RFP and scope were 38 pages long, and they covered these 7 primary goals that you can see on your screen. Those were the things that we were interested in, that they identified in the plan and provided strategies for. In July of 2019, we were awarded the grant through the Department of Defense for $384,641. There's a local match of 10%, which the participating communities and us shared. And in addition to that, the Utah Defense Alliance provided $5,000 towards that match. They were instrumental also in the process up to this point in time. In December of 2019, Matrix Design was awarded a contract by the City Council through Resolution 19-56. And finally, in February of 2020, we had a kickoff meeting in Clearfield with the elected representatives, including the city councils from, at that point in time, 12 different cities and 2 counties still. And it went well. And then you all know what happened immediately after that. COVID put a lot of things on halt. Matrix, our consultant, did a great job by turning a lot of the meetings and things that were supposed to happen in person virtually, and they were able to continue that process. Since that time, we've held 18 meetings. 3 of those were public hearings where they took public comment.
They held 47 stakeholder interviews. These are everybody. We were involved as our city, the mayor, the city manager, the city attorney, and the department heads for public works, community development, and engineering, along with the fire chief and the police chief as well, to give them our thoughts of items that we were concerned about that could be addressed through this process to help, mostly with communication for us, but some other items that we thought might be a concern that we could address through this process. At the end, through this process, you can see that we have 12 cities that were involved and 3 counties, and they're identified there. This is a list that's not complete, but it gives you an idea of who was involved, and it was pretty substantial. Not only we had representatives from Hill Air Force Base, but we had our federal delegation, several of them. They weren't able to comment. They're not allowed to through this process because of the federal grant money, but they sent staff to basically be in the room and take notes and communicate. But we had state legislators that were involved. And then we had many groups from the state down to local involved in this process. We also had local employers involved in this process. And then we had several adjacent landowners and residents and others that were concerned about things that are identified in the plan. So that's kind of a wrap up of the process that took place to create this 372-page plan that's very comprehensive. It was a creation from everybody involved. Matrix did a great job of getting them to collaborate and to bring all that information together. It was not an easy task bringing that many elected and appointed officials and all the others together for multiple meetings, but it was definitely a great opportunity. For 2217, now that we have a plan in place, it has no regulatory authority. So the next step is to go through the process to implement the plan. And that's where there will be processes for many years to come from the city council and the city and the residents to decide how we want to go about that process. There's recommendations in the plan. As mentioned, there's 110 recommendations for 43 concerns that were expressed. That doesn't mean we can't come up with our own as well in addition to those or with those. And so that will be the process coming forward. So Resolution 2217 recommended by our consultant is to create an implementation coordination committee with the several communities and other stakeholders involved. A lot of that involves really setting up better communication between us and the base and surrounding areas. We do a pretty good job, but there's always room for improvement. There's other cities that don't communicate as well. So this is a really good opportunity for us to create that process where we can all communicate better. But that's just one of many of the opportunities that have come through this process. If you drive around Hill Air Force Base, you'll see that they're starting to actually implement some of the items that are discussed in the plan. So this is a good thing between us, in my opinion. That's my personal opinion. And so with that, staff, we recommend that the City Council consider approving, adopting, and accepting Resolution 2216 and 2217 as submitted. And I'm happy to answer any questions.
Okay, Council, I know we went over this a little bit in our work meeting, but certainly you have an opportunity here to ask any additional questions you might have. Mr. Morse?
Yeah, just actually more of a comment. Thank you for spearheading this and for us being the chief sponsor. That was smart as well. We're grateful for we want to be good neighbors, and the base wants to be a good neighbor. And this is vitally important as we move forward. as far as planning for that good relationship between the base and Layton City. I mean, these are so many families live here and benefit from the base. We learned earlier that, and this isn't new information, but the base is a $4.5 billion economic driver for the state, for the region, obviously for Layton City. So I'm grateful for this plan. I'm excited moving forward. We have to have good relations and a good relationship with the base moving forward, because without community support, I mean, the base can't close. And part of and it's not just, the criteria is not just how is the community, but it is a factor. It's an input. Are you welcome in your community? Hill Air Force Base is welcome in this community, and I'm excited to support these resolutions tonight and move forward as we plan. So thanks, Lon. Appreciate it.
Thank you.
The only other thing I'd add that was excellent is that it isn't just the base, it's also the communities around us. I mean, Lon, great job on bringing all the cities together on this, and knowing that going forward, it's going to require all of us working together as well. Even though we can identify our own specifics here within the city, it's a matter of working collectively together. So I'm very much impressed, and you have a lot of tenacity, kid.
I'd echo what's been said. I mean, this is a huge asset, even just the report as it is, to our planning and zoning departments, just as a reference tool. I think it could be a great tool to use in the future. Just one question about the implementation committee. Is there funding needs for that, or is it going to be just on your own? Are those who participate are paid in their position they're in?
Yeah, it would be volunteer or paid by the city that they represent, or county, I guess. Up to this point, that's basically how it was operated through this process. Is everyone was invited to participate, and those that were willing to, and offered by their community to do so, were able to participate. And I would imagine this would continue in a similar manner. We were pretty successful in having representatives from most communities throughout the process, different parts of it anyway, and so it's probably going to be similar to that. It's up to us to decide how we operate, but there's not funding that I know of right now to pay anyone.
I need to comment on that. Didn't Mr. Patrick Small, who is also very instrumental in conducting this, didn't he allude to the fact that there could possibly be additional funding federal funding that we could go after to help?
If that program's funded, then there could be possible funding available, yes.
Okay, thank you.
Thanks again, Lon. I appreciate it. Kind of piggybacking on Councilman Roberts' discussion about potential changes to zoning. And if you can't answer this, that's okay. One of the things I noticed was in the airfield safety zone, they said that we, as the city, could consider amending zoning ordinances to incorporate Department of Defense land use recommendations from a 2018 Hill Air Force Base study. And I guess I was surprised that wasn't already something we were doing, and it may be something we're already doing. But I don't know if you can speak to that or the staff. It was just, I know we've had discussions about what we can do in now those particular areas. I was just curious if we know what those studies are and what those land use recommendations would be. What would the zoning change be? What are they recommending?
Yeah, those are identified in the plan. There's different recommendations from both the FAA and the military based on the airport. All of those are health and safety related. When it comes to us, there's concerns about takings and other things like that. We have to be careful through that process. There might be funding through the DoD. The state might be able to participate like they have in the past to help pay for some easements. And so that won't be an easy process for sure. And that's kind of how that will have to take place moving forward. It will be a public process.
Does it change from the BRAC? I mean, is there an addition to BRAC or lessening?
I don't know if I can answer that question.
Because we've gone
They
through
seem to
quite
be,
a,
yeah, it's been mentioned they're more favorable to companies that show an intent to protect the interests of a military installation, but that's not, it's impossible for me to answer
yeah,
that
no,
question.
I'm not.
So.
If I could just piggyback on what Lon said about the zoning, the plan itself does not make any specific zoning recommendations. It talks about land uses. So it'll say, these are the types of land uses that we have concern. Zoning decisions are firmly on your shoulders. So we have a general plan. That's what we would still continue to use to guide our zoning decisions. And yeah, this plan gives all that authority to the city council for the actual zoning and those types of designations.
Yeah, it wasn't to say that they would have land use authority. It was just, our general plan is pretty new. And so I was just, I don't know. I guess maybe it's easy for them to write, we need to amend our zoning ordinances when maybe they don't know that we just updated our general plan, and we would probably have those things already in place.
Yeah, and that was looked at during that general planning process with the knowledge that this process was on the horizon. This has been, as Lon said, this has been contemplated for years. So we were adopting our general plan knowing that we were going to have this follow-up process. But there will be many more discussions about what appropriate zones should be within those areas they identified.
Okay, thank you.
Okay, one last question, just because I know it will probably come up, and that is the plan, the availability of this. Will it, where could, if the council decides to adopt this tonight, where would that be available so our citizens can look at it?
We have a project website, which will be up for about a year. You can download a copy of the plan. If you go to www.hillafbcup.com, and you can see the link at that site to download the plan or view the plan. Okay. Not only that, but all the information regarding the process and all the documents that took place in the meetings are all there if you would like to review that as well.
Okay. Thank you, Lon. And once again, thank you for doing all that you did and leading out on this. Okay. Okay, I think that pretty much concludes our consent items as far as the presentations. So council, I'll turn it back over to you for action. This will be a doozy. Yay.
We can do this all in one motion.
You can.
All right. I move that the council approve the consent items. I'll read them. Item A, appointment to the Utah Telecommunication Open Infrastructure Agency, Utopia, Resolution 22-10. Item B, appointments to the Parks and Recreation Commission, Resolution 22-08. Item C, appointments to the Planning Commission, Chris Crowder and Scott Carter, Resolution 22-09. Item D, amended plat for Indian Springs Creek Subdivision, First Amendment, 1329 East Indian Springs Circle and 161 South Indian Springs Drive. Item E, amended plat, Willow Cove Estates Phase 2, First Amendment, and Whispering Willows Estates Phase 4, First Amendment, at 684 South, 275 West, and 302 West, 700 South. Item F, accepting the Hill Air Force Base Compatible Use Plan in good faith and endorsing the implementation strategies as identified in the plan, Resolution 22-16. And item G, endorsing the formation of the Hill Air Force Base Compatible Use Plan Implementation Coordination Committee, Resolution 22-17.
Perfect. Is there a second? Okay, it's been moved in second that we act in the affirmative on all the items presented. Is there any other discussion? Okay, seeing that there's none, I can I do not have to do a roll call vote on this. So, council, all those in favor of the consent items as presented, please say aye.
Aye.
Any opposed? Okay, thank you very much. That's unanimous. We'll now move on to our public hearing portion of our meeting. We do have 3 items that are part of our public hearing. So the first one up is about our Community Block Grant Award, and Mr. Morgan Cloward's going to present that for us.
Thank you, Mayor and Council. Just to give you a brief background on the Community Development Block Grant, or CDBG program. This is administered by the U.S. Department of Housing and Urban Development, or HUD. And some of the eligible activities that Layton City has been participating with the CDBG program include some of our public services, Open Doors, Safe Harbor, Lantern House, Youth Court. We also have housing projects, including our Home Down Payment Assistance Grant. And we also have economic development activities and assistance. The stipulation from HUD with this funding is that these activities must support, benefit low and moderate income persons within the community. The plan that we're talking about tonight that's coming up is the program year that runs from July 1st, 2020 to June 30th of 2023. Our current funding that we're using right now was for Annual Action Plan 2021-2022. And this Annual Action Plan, it outlines how the city will allocate its allotment of CDBG funds during the upcoming program year. And as you can see on the next slide, tonight is our first public hearing for the Annual Action Plan. HUD requires at least 2 public hearings. And the first one, the purpose of that is just to gather feedback and any comments that we might have from the general public and some of our subrecipients and others that participate. And then we also have a second hearing that's required by HUD, and that one typically happens during May. And we also gather more input from the public at that time. And then if everything looks good, then we go ahead and we ask the city council to adopt that plan. And then just that last slide I have for you is just a rundown, a breakdown of the current activities that we're running right now with the city, including, as I said, homebuyer assistance, down payment assistance. We had a recent Davis School District home that was constructed here in town, where we had students from Davis County School District participate in that. And then you can see some of our public service activities: Open Doors, Safe Harbor, Youth Court, and Lantern House. So that's a quick overview, brief view of CDBG and the upcoming Annual Action Plan. And before, I know we have a few of our subrecipient representatives here that would like to say a few words. I just wanted to open that to you to see if you had any questions for me about this.
Council, do you have any questions before we open it up for public comment?
Yeah. Okay, Mayor. Morgan, a couple of questions. Do we know how much it'll be for the next program year?
We don't. We know it's a formula based on employment and, the how healthy the local economy is and other factors. It's typically around the amount you see up there. It hovers up over and below 400,000 typically. So it'll probably be around that range.
So you mentioned that for low to moderate income, how is that determined? And are we moving? When is that determined? And is that a census item, or is that every couple of years or every year where we determine what the income is?
Yeah, so HUD will release those every year. What the household income limits, what they do is they say for a household of 4 or 5, your threshold is this certain amount. And so if I have someone apply for a down payment grant, I have to look at their previous tax return and also some of their pay stubs just to make sure that they're not exceeding that amount, for example.
Is our median income in Layton City, is it going up?
It is continuing to rise, yeah.
Which means we might get less money. Is that, it's not
Yeah, it really depends on how well our local economy is doing. Yeah, in past years where we weren't doing as well, we received a higher allocation.
Last thought is with COVID and the stimulus money hitting the economy and people taking that money and turning around and spending it, the numbers could be overinflated as far as the economy going, as far as what other factors do they look at to keep that from happening, from being overinflated?
I don't know all the specifics, but I do know that we've had some separate COVID funding that we've received from HUD, and I do know some of the requirements, some of the regulations. They have made it to where it's a little bit easier to help your citizens in your community with, for example, with this annual action plan that we're proposing. There's a cap. There's a 15% cap that we have on a limit we can allocate for our subrecipients. With the COVID money, there's not a cap. They suspended that. I hope in part that answers what you're.
Yeah, no,
okay.
I just, these are maybe for the new council members as well. I appreciate this program and all that you have. I mean, you're a champion of this, and it's not just when you come up here and present and that's all you do. This is hard work, and especially with that COVID money and all of the incentives for small businesses and the families. And I mean, I appreciate all that you do in implementing this, and I would imagine the subrecipients do as well. You're just great to work with, and I appreciate it, Morgan. Thanks.
Thank you.
So, Council, I'm excited to hear from some of the subrecipients. I see them here, but we need to open up our public hearing at this time. So I'll look for a motion to open the public hearing. Okay, is it seconded? All in favor, say aye. Aye. Any opposed? Okay, thank you very much. So if any of the subrecipients would wish to speak to the topic, please come on up.
Mayor, Council, Open Doors would like to thank you for the past support we've received. I can answer your question about LMI. Low, moderate income people are between 125%, 200% of the federal poverty level. And as Morgan stated, it depends on the size of their family. Average size family in poverty for Layton City is a single mom with 3 kids. That would put her at about LMI is $27,000 a year, 200% of the poverty level would put her at about $38,000. So that's what they would have to make in between those to receive services. Open Doors, what a year. We've had a great year. I just want to say thank you, and I want everyone to recognize our staff at Open Doors has worked so hard this year to help everybody in the community. We were granted by the county the Emergency Rental Assistance Program. We served over 6,000 families and dished out about $2 million in rental assistance. We were second in the state for having the most applications approved. Then the state went and they've taken it back over. However, Open Doors did such a good job in helping these families, they'd allowed us to keep doing community outreach and helping the community get the word out. So we're very proud of that. Just to inform you, we had our point in time count last month. For those of you that don't know what that is, it's when groups of people get together and go out at 3 o'clock in the morning and count the homeless. We actually had 34 people. 90% of them were from Layton City. Most of them were found in the Cracker Barrel backyard in their parking lot there and Walmart. We did find more than the actual 34, but only 34 would agree to do the survey, and that's all we're allowed to count. How many people we actually count that night is based on the HUD funding we receive from the federal government. So fortunately, we found a lot more than that. They won't do the surveys. We can't help them. Since July 1st, our food bank has passed out 2 million pounds of food. Because of COVID, we can't have actual people come into our food bank. So we have created ways to provide the community with food. We've been doing drops at Department of Workforce Services, different elementary schools, high schools in the area. Big problem is we've seen a 50% decrease in our grocery rescue program. Grocery rescue is where local grocers get together and they pass out food that are kind of like what you see the manager specials. It's a great idea. They come, they drop it off to us. It saves them the money in actually having to throw away the food, and we can pass it out. So we've seen a 50% decrease in that donation. Plus, we've seen an increase in the poundage of food we're giving out. So that creates a huge problem. Again, we still are assisting families with our family support. Because of COVID, we can't take as many families, but we're still seeing a huge demand for the families wanting to use our nursery. So that's where we're at right now with that. Again, I'd like to thank Mayor Petra with her help with Cedarwood. Cedarwood is a mobile home park that is going to be dispersed. As of March 9th, 14 families had to relocate and move. We were able to place all of the families but 2. So that's good news there. So hopefully we only have now 100 other families we have to place in the next couple of years, but good start. I'd be glad to answer any questions anybody has with Open Doors and what we've been doing.
Do you take volunteers?
Yes, we do. We're limited in the number of volunteers we can take and where we can take them right now, but you can go to our website and just put in your name, and we usually, right now, we're taking volunteers to do the food in our food bank.
If we have a group, say 10?
Sure.
That you're still okay?
Yes,
we just go to the website?
Just go to the website and put in your information, and
Right.
then we contact you based on what day you'd like to come. So we can take a group of 10, and you'll be sorting food. And we do take kids as young as about 10, as long as they're with a parent.
These would all be junior high, high school.
Perfect. Mm-hmm.
And they, I just lost my train of thought. You talked about how they would, are there any days that are better?
Our food bank, we actually take deliveries. So on Tuesdays and Thursdays,
Okay.
we have our volunteers come in because our food bank is
So
closed
that'd be
to
the
the
best
public.
2 days?
Mhm. Yeah.
Okay,
And
thank
I
you.
am aware that I think the Layton Rotary Club is actually going to be up there next Wednesday to
Wednesday
well,
night,
help
yeah.
them out.
This is for the youth
Club.
council.
Yeah, right.
Yeah.
So yes, we do. We also, too, we have a Circles program that the youth get involved with, and it's an incredible program. I don't know, Circles is a peer mentoring program where you take low-income individuals and pair them up with middle to upper middle class volunteers. As a matter of fact, I was at Circles tonight. I have a great story. Let's end up on a great story. I teach Big View for our Circles program, and that's about the political process and the importance of voting. So we had this woman that was there, and we were talking about eviction notices and how there's a bill up that's going to expunge people's eviction notices after a year. And she was saying that she had been evicted from her apartment due to a domestic violence issue and could not rent an apartment. She went through Safe Harbor, and they helped her get her apartment, get settled. She's doing so well now, so she's taken the next step to join our Circles program, and she started her own business where she's putting together a book of resources to help other people that have been involved with domestic violence situations. On the money, she wanted to go volunteer with Safe Harbor, but obviously there's a time period that she has to go through the program. But this woman, she actually started crying, saying that she felt so relieved that she found Safe Harbor. She still had a support system within Circles, and she was doing this all on her own with her kids. So thank you for your support of everything that you do.
Thank you. And that's a prime example of 2 important agencies working together.
Great
So,
story.
Thank you. Yeah. Okay, next.
Mayor, City Council, I'm Carlene Kidman with Layton Youth Court, and I thank you for all your support. We're in our 24th year, and we have heard over 1,850 cases in 23 years. And I'm just going to talk about what are some of the statistics from last year. 97% of all our cases completed youth court program, and I can tell you why the 2 that didn't, complete. So, but most of our cases has changed over the last couple of years. Most of our cases now are possession of marijuana, and it's not the old-fashioned marijuana that was when I was a kid a million years ago. It's vaping, and these kids are vaping not only tobacco but marijuana is, pure THC. So that's a whole nother story, but that's most of our cases. We've had so many cases lately that on Wednesday nights, we've been running 3 different panels just to catch up. Last night it was, the kids kind of went, that's nice, only to go back to 2 panels again. So we've had a lot of cases. Right now we're only in February and we go till the end of June. We've heard more cases than we did all of last year. So we've been getting a lot more cases. Like I said, most of them are marijuana. But I wanted to tell you, talking about poverty stuff, I'm going to tell you a little bit about just the offenders from last year, for our statistics. 85% of the offender families are below 50% or more below poverty level. So we are seeing the more poverty. 82% of the offenders have what's called an individual educational plan, which means they're in resource classes. So that's a high statistic that no one else in the state keeps, but that's something that I keep here in Layton because I've actually had conversations with Davis Behavioral Health about this statistic to see what we can get into to help these youth stay out of trouble. 21% of the cases last year were elementary school kids, with the youngest being in 2nd grade. So some of these, they're starting out younger and younger. 49% of the parents approve of their kids' friends. That means 51% don't. So just so you know. 43% of the youth offenders say 1 to 25% of their friends use drugs or alcohol. 62% of them said they are leaders, so that's good. 41% of the families are single households, and 24% of the families say there is a disability in their family. And 3% say grandparents are raising their children that came to youth court. So that's just some of the statistics that we are trying to help in youth court, trying to help these families and help these youth get back on track. 91% of the cases said that after completing youth court, they are making better choices and they want to move forward and not do what brought them to youth court. So that's a really good statistic that we're really proud of. And one of the, like I said, going on a high note, one of our biggest things this year that I am very, very proud of, our current little, I call her little because she's just this teeny petite little girl. Our president this year is a former youth court offender. She came through youth court several years ago and has changed her life around, and now she is our current president. And she's very pleased about that, and she will tell you all about it. She's the cutest little thing. So if any of you are ever wanting to come and look what these kids are doing, they're phenomenal and turning around, and actually they care and are trying to help these youth. Come in on Wednesday nights because we're in here doing youth court. And we wouldn't be able to do it without your support. So I would just ask that you continue to help support through this grant so that we can continue doing our program. Do you have any questions?
Council, any questions?
Okay. Thank you.
Arlene, you do a fabulous job. Thank you so much and for hanging in there and really
thank you.
Make it. I mean, you represent the city very well.
Thank
and I
you.
appreciate that.
May I, Madam Mayor? Yeah, Carlene, just you give your heart to those kids in this program. It is all of these percentages and 91% of the youth court, they're making better choices. They might not have a 2-parent household, but they got a mom when they go to youth court.
Thank you. One other thing that was really interesting, I went to a meeting yesterday, and one of the gals that was on the agenda to present was one of my former youth court girls. And so now she runs a program in Clearfield High School. So I'm going, hey, remember us? And she goes, yes, I remember youth court. So, it just keeps going around. They come back and they are working in our community. So,
well, they're lucky to have you. We're lucky to have you.
Well, thank you.
Can I make a comment, Mayor?
Sure.
Carlene, just sorry. Just my thanks as well for all that you're doing. I think I remember last year there was a question about the funding, and funding was increased. Just make sure that you request enough for what's the right amount, but enough to take care of these kids would be my suggestion.
Okay. Thank you.
Thank you.
Yes, thank you.
Yeah. Excellent. Next.
Good evening, Mayor and Council. My name is Kristen Floyd. I'm the Executive Director for Safe Harbor Crisis Center. And for the new council members, that is the Domestic Violence and Sexual Assault Crisis Center. We are the only service provider in Davis County, and we've been here for 25 years. Unfortunately, over the past couple of years, we've been experiencing an extreme increase in our services needs both prior to COVID and during and because of COVID. To address those increases, we have been going through expansion efforts. Some of you will have noticed we have a brand new building that is almost to completion across from the Intermountain Layton Hospital that will open up in May. That's our Lifeline and Prevention Center. That facility handles individuals that are not in imminent danger, don't need immediate shelter with our crisis shelter or transitional housing, but will still need services associated with domestic abuse that they've experienced. That might be free therapy for their children, protective orders, advocacy services, sexual assault exams, unfortunately, and other types of advocacy services. We do psychoeducational groups there, healthy relationships, and work with the schools. And that's all housed out of that Lifeline and Prevention Center in Layton. In addition to that expansion, unfortunately, we will also need to expand our shelter and our transitional housing units. Those are on our Kaysville campus. Right now, we have 31 beds in our shelter. With COVID, unfortunately, it prohibits us from housing people in that shelter the way that we've been accustomed in the past. And so the 31 beds quickly went down to 13. We were already at capacity prior to COVID, and we're always full at that 31 beds. So you can imagine the challenges that we have had through COVID. We've been able to utilize some different hotel situations, and the city and counties have helped us with those funds. However, that's not a safe place for us to put victims. We had an issue a few months ago where the perpetrator found the victim at the hotel, kicked in the door, and took our victim. And so that's clearly not a safe place for us to continue to house them. And so we really do need this expansion in order to provide services to those victims. Our transitional housing apartment complex, we have one located there on our Kaysville campus now, has 10 apartments in it. We house individuals and families for anywhere from 6 to 24 months. While they're at transitional housing, they receive wraparound advocacy services that is also free, children's advocates, adult advocates, diversity advocates that speak other languages to assist individuals in any capacity that is necessary to get them back to a healthy lifestyle for themselves and their family. We're very grateful for the support of Layton City over the past few years and are looking forward to utilizing future funds from Layton City. We'll be putting in an application for those funds, but just wanted to say thank you for all of your support, not just financial support. I know the mayor's been to a multitude of events, and the others have enjoyed some of those things as well. And we just appreciate that support, both in kind and financial support. So thank you. If there's any questions.
Questions?
Just one question. Could you maybe explain your relationship also with victim services here in Layton City?
Yeah, so we work, those would be what we call systems advocates, and many of the cities within Davis County have those advocacy services. And so what we're able to do, the difference there, for those of you that don't know the difference between a community advocate and a systems advocate, we are community advocates and we are bound by a vow of confidentiality requirement. Systems advocates are not, and they work a lot more on the legal side of the advocacy process for those victims, where we are perhaps working on a different side of that would allow us to keep those conversations and situations confidential as they come in. A systems advocate may be bound in court to testify or release information that was discussed, and the community advocate isn't. So that's just the difference. But in conjunction with that, we work heavily with the systems advocates to be able to connect them so that that systems advocate can help them on the legal side so that we get justice for them against the offenders that have created the domestic abuse. So we're very grateful for the systems advocates that have been created throughout the county.
Thank you. Any other questions? Okay.
Thank you. Appreciate it.
Okay, we have one more.
Hello, I am Shelley Pace. I am here representing Davis Community Housing Authority, and we operate the Emergency Home Repair and Rehabilitation Program. Some of the exciting things that have happened lately is that Morgan has expanded the program to allow for water efficiency as well as being more creative in cooling, where, things are heating up pretty substantially. And so trying to think of new ways of seeing that. One of the things that I've noticed is that once people do apply and realize that they can do windows, they go for efficiency windows instead. But so on emergency home repair, it's basically for anything that this is an emergency situation that they're in danger as far as heating, cooling, water heaters going out. So in those situations, we'll go in and have a contractor go in and replace those so that they can be back to a good condition again. On rehabilitation, that's more about improving the home. So that'll be a lot of the roof repairs or replacements, as well as window replacements to be high efficiency. And those programs, the emergency home repair grant can go up to $3,000, and the rehabilitation is up to $5,000. And I did want to touch briefly on the income limits and AMI. So area median income for Layton City is within the Ogden declared field established from HUD as far as what that 30, 50, and 80% thresholds are. And so those will be published in a few months, but that's something that just on an annual basis. And it seems like it kind of goes up by around 4,000 to 5,000 for that family size. Seems pretty typical. That's not to say how much would be allocated to Layton necessarily, but as far as how area median income is determined. And I haven't spoken in front of more than like 2 people in a while. So
You're doing great.
Yeah, thank you. Do you have any questions?
Council, you have any questions? Hey,
Okay.
thank you. Yeah, we appreciate that. And I just want to make a quick comment. I know some of the others have left, but obviously you can see the passion that each one of these representatives have. I mean, they eat, sleep, and drink who they are advocating for, and I'm very impressed with the dedication and don't feel nervous at all.
Thank you. I also wanted to say the Circles program that Open Doors runs is amazing. I've had people come and talk to me about how much their life has changed from that. So just want to call that out.
Thank you. Okay, that's our first item on our public hearing. And being that this is a open program, we're not taking any action on that item tonight, correct? So it's just a matter of public hearing on item A, which was the community block grant plan. So I'll just go ahead and move on to item B. Is that fair? Okay. Let's go on to item B, and Mr. Chad Wilkinson, I believe, is presenting that item for us, which is a proposed amendment to the Layton City Municipal Code.
Thank you, Mayor. We're just going to take a moment to transition back to our other slide presentation here. Just one moment. I'm not trying to make you car sick here. Sorry for the quick. Don't look at the screen. Yeah. We're going to move past those slides very quickly. So we've talked a lot about this particular amendment in the past with the council at work sessions. This is something that is a standard that goes way back. This is a standard that was adopted in 2002. So it's been on the books for about 20 years, and it was related to landscape buffers along our arterial and collector streets. Now, up on your screen, you can see a great example of what this ordinance was meant to do. This is one of our arterial streets in the city with that landscape buffer in place. You can see the beautification that does, especially along those properties that have their rear yards along that arterial street, and that's what it was meant to do. We have found there are in the ordinance, excuse me, there are two types of these buffers. One of those buffers are established in common area that's owned by the homeowners association. The other option in our current ordinance is to allow for these types of buffers to be installed within private easements that are part of the adjacent property. Unfortunately, we have found that occasionally, for the most part, we have some version of this out there, a very attractive landscape area, but occasionally we do have buffers that turn out to look a little bit like this on the screen. And that's what we found, is that predominantly in those situations, those are buffers that are not within those common areas, but within those private easements in private properties. Those buffers that are established within common ownership with a homeowners association maintaining those typically are maintained in perpetuity very well with good watering and excuse me, maintenance of lawns and other things. But with these other options where we have an easement, sometimes that doesn't happen. So there could be a variety of things. Either the buffers are never installed, they're not maintained properly, or that the homeowners association is never fully established or functioning, and that there's discrepancies in how those are maintained. So to address that, we are proposing some changes to our current ordinance. The first of those is that we would no longer allow for those buffers to be established within a private easement. They would have to be in common area that's owned and maintained by a homeowners association. In order for us to facilitate that, and because before the developer or the property owner had the option of providing that within an easement and maintaining that property, we are proposing a minor density increase and some lot averaging in order to make sure that there's no issue with any kind of a takings claim. This would provide for them to have a trade-off in providing this buffer area and avoid any of those types of takings claims for this particular buffer to be installed. We also saw a need for us to strengthen our language related to CC&Rs. That's conditions, covenants, and restrictions that govern the homeowners associations and how these landscape areas are maintained. We also have put in some language that we would call, we've been calling this kind of the last straw language, which is if there's, through all of our efforts, if we're unable to get compliance with these landscape standards, we do have the ability to impose a fee for landscape buffer maintenance. Now, I want to just explain that a little bit. This would not be something where the city would impose a fee and then the city crews would go out and maintain the landscaping. This would be a situation where, much like an HOA, there would be a private landscaping contractor that would be contacted, bids given, a contract that would be entered into, and then those costs would be passed along to those property owners that are not willing, or for whatever reason are not forming that homeowners association to maintain these landscape buffers. The impacts of that are that this is not intended to be a way for property owners to simply pass that maintenance along to the city. There would be some type of administrative fee that would go along with that. It would function to a great extent as a special assessment district that would be formed for that particular group of properties that could then be formed in order to maintain that very specific improvement. So that's one thing that has come up as we talked through this with the Planning Commission and others, and we wanted to make sure that that was clear. Rather than go through all the specific language of the ordinance, we have gone through that with the council a little bit in our previous meeting. Happy to talk about the specifics. I just want to focus on a couple of things. These are the standards that apply to lot averaging. The RS zone, which is our residential suburban zone, already includes the ability to lot average along these arterial and collector streets. We'd expand that out to the R1 zone, and that's, again, in order to try to avoid those issues of takings. This would give those folks the ability to average their lots along those arterial and collector streets and to get a little bit of a density bonus within 300 feet of that arterial or collector road. You can see those numbers. This is something we discussed at length with the Planning Commission, and these are those, how that works out. Essentially, a half a unit per acre within that first 300 feet of arterial and collector road. We have also, not going to go through this language all in specific, but these are the standards that we've adopted to beef up the language related to our conditions, covenants, and restrictions to make sure that those are strong enough that we can make sure that those are established and that those are maintained after they're established. This also gives the city a seat at the table with those CC&Rs to make sure that they aren't removed after the homeowners association is formed, that the city would be a party to those to make sure they couldn't dissolve the HOA or make changes to the modification of that landscape buffer without the city being involved. We do have that language again related to imposing a fee. Explained that a little bit earlier. That would include the provision for, in some cases, installation, 1-year warranties, those things to make sure that landscaping is maintained. I want to just mention really briefly that as this has been reviewed by the council, we have had some grammatical changes that have been identified. Those have been included. We did have one additional grammatical change that was identified. Actually, this is not a grammatical change. This is an actual typographical error in one of your tables that's found on page 6 of the ordinance and 82 of the, let me make sure that's 82. Is that correct? Page number 72 of the packet. There's a table 16-1. And there's some erroneous language there. It refers to a section 16 point. Can you give me that section number again? I just page 82. It identifies section 16. Thank you. 16.16.070. It should be 19.16.070. So that was a mistake on the transcription of that code. So we would include that in our motion as well as those typographical and grammatical changes. Be happy to answer any questions. I want to acknowledge right now Weston Apollonie, our city planner, who is the primary author of these changes. I'm going to tag team with him on any questions you may have about the ordinance or any questions that come from the public about the proposed ordinance, and be happy to open that up. This was reviewed by the Planning Commission with actually a continued meeting for further review so they could make sure they understood these provisions. And then they did recommend that the council approve this proposed landscape ordinance amendment.
Okay. Questions, council?
Mayor, is that okay? Mm-hmm. Chad, just a couple of questions. Actually, first of all, thanks, Weston, for all the work on this. I think you struck a good balance in what you were trying to accomplish with the developers and the small density and the community benefit of having it look like that first slide.
Yeah, that's the goal.
And not the second slide. But I don't know if that was in Layton. That might have been somewhere else.
That's Layton.
No. Okay. Well,
unfortunately,
just a couple of questions. So back maybe to that second slide. What happens I know this is moving forward. What happens to the issues that we've had in the past with this ordinance? So that's one question. And then second, maybe it relates with code enforcement moving forward. If you mentioned if there isn't a HOA established and you're saying, okay, well, great, we'll just have these, for instance, these four residences or these 4 properties should have been in an HOA. Now they're not. So we're going to do the maintenance or we're going to bill them. What if they say, you know what, still not going to pay, still not going to do, what recourse do we have at that point? So those 2 questions. Thanks.
So the first question, the ordinance already exists. This is a requirement on any property that has that rear frontage, or that's kind of a weird way to say that. The double fronts in arterial collector street, they have a rear yard that abuts that arterial collector. So the requirement already exists. That code is on the books. They are subject to that code today. What this does is it gives us some additional tools if for whatever reason we can't get that compliance. We would hope that through discussion and code enforcement, and for many of these, that's been enough. We've said, hey, we need you to go out there and chop the weeds down or replant some trees or whatever the case may be. But in those rare cases, there's a few of them, but in those rare cases where that's just not working, we have that additional ability to impose that fee and to go out there and maintain that. So they are required by law to comply with that code. They can't say we're not going to comply with your code. What this does is give us the ability then to impose a fee that would allow us to intervene and to go out there and provide that maintenance.
They still don't pay after that. So
if they don't,
what are we doing now then? What's the next?
Whatever the procedure is for a regular utility billing, maybe that would be something to answer. But there'd be a process that we could go out and collect that fee.
So we place it on their utility bill, and they must pay it as any other item on the utility bill. So if they fail to pay their utility bill, they get their water shut off.
Okay, just case in point, if you look at this photo here where there's no home built there and there's probably no services that you would add to the monthly bill, at that point, Gary, could you lien the property to make sure that these folks take care of it?
Yeah, what we would do at that point, it becomes a debt of that property owner. Mm-hmm. And we would go after that debt, reduce it to a judgment, and then put a lien against the property for the amount of the debt. The same way we would, well, you don't have water being used by a vacant lot.
Yeah, and that was my case there.
So yes, we would reduce it to a lien, a judgment to a lien, and then same way we would for any other collection, so.
One other thing that we've done that's outside of the ordinance is we've changed our processes in relation to the installation of these buffers up front. So that's been tightened up to make sure that that we don't have people. The buffer itself is required to be installed by the developer as part of the development of the subdivision. So we've made some changes in our policies and procedures, and also with our new online building permit tracking software that puts a hard stop on certain processes to make sure these are in place before they get too far along. So we hope that first step of changing those policies and procedures will keep those from not being installed in the first place. We might still have some issues with maintenance down the road, but we hope that'll fix that problem.
Thank you, Chad. Councilman Bloxham?
Yeah. So the ordinance has already been on the books since 2002. The fee is new.
The fee is new. Yep.
So when I was going back through the discussion in the Planning Commission minutes, I had the same question as this, and the answer from the staff was the fee section can be retroactive to those who are already not maintaining the buffer and are non-compliant with the current code. Is that correct?
Yeah, I'll tag team with Gary on this one, but yes.
So they can be subject to a fee that was not in place retroactively for their non-compliance.
Yeah, so the obligation existed. When you say retroactive, we can't go back and bill for anything in the past.
Okay.
But what we can do is say, this isn't working.
Right.
It's not being maintained. And so we will impose a standard and a requirement. And from this point forward, and we do that in many.
So the retroactive standard is to say these people have not been in compliance for a long period of time, which is what I read in the actual ordinance. But the dollar figure starts when the fee is implemented today.
Correct.
Okay.
Yeah, we don't go back in time. To your point, it's not retroactive in that manner.
Okay. Council?
Is through code enforcement? Is that how that will work?
That's where it'll start.
That's where it'll
Certainly,
start.
we'll have to go through, if we come to a point where code enforcement's not enough, then the next step would be for us to go through a process to figure out what that fee would be. It's going to depend on the number of lots in the subdivision, the cost of maintenance, the length of frontage, what that would require. Sometimes installation would be a part of that upfront fee. So,
Any other questions?
Yeah, I have a bit of a different question. So it's been stated in the work meetings and also tonight that it's a last resort for the city to come in and impose the fee and then take care of it. And I know that there is some leeway for where there are not enough properties perhaps to have an HOA. But what if there are a small number of homes that the HOA is just, too much? It's a big burden or whatever. Is there any, not leeway, but any encouragement, or the city will work with a group of homeowners who want to come together and allow the city to do that for them? They'll pay the fee, but where it doesn't seem like it's a punitive thing. I mean, because this is last resort, but what if they say, yeah, we want the city to do this and we're willing to pay that fee? Is there a way for them to come to you without it becoming the last resort? Does that make sense?
yeah, I think we'd want to work with people first. That's the first goal, is to see if they can. I think what the intent of this is for them first to be able to organize themselves and try to keep that fee as low as they can through competitive bidding, through a landscape contractor or whatever the case may be. As far as them coming to the city to maintain these, we're not interested in the city maintaining. So our process would be very similar to what they would go through. We'd go out and solicit bids. We'd say we got to divide this cost up by whatever the number of lots are that are in the subdivision. There would have to be some type of administrative fee because we would be having to keep track of these every month and issue the utility bills. Our guess is that is going to be more. And I say guess, this is an educated guess. We've sought for bids from landscape contractors and looked at that divided by the number of lots for a few different scenarios. And so we believe that that's probably going to be more expensive for the city to do that than for them to just organize together as a group of homeowners and provide that service themselves. I hope that answered the question. I don't know that we have any type of what's the right word, assistance necessarily available or planned, but as they buy those lots in that subdivision, they should be aware that there is an obligation for maintenance of that landscaping through their covenants, conditions, and restrictions, and just through the title report that goes on during the purchase of the home. And also, this will be one of the other things we've added is more clarity on the plat. There will be specific plat notes that describe exactly what is required and reference back to code, so that when people look at a subdivision plat in the purchase of the home, they can say, okay, there's this plat note, and I need to understand what that means. So, yeah.
Anyone else?
Mayor, go ahead.
So you mentioned an instance where maybe an HOA wasn't formed, and looking at this picture, you say the ones that the buffer is closest to, we would bill, when in actuality the whole development has a responsibility for that. Would you bill the entire development that should be under that HOA?
Yes. Yeah, the intent would be that everybody that's under that obligation, which is the entire development, not just those. That's been one of the issues with having them in a private easement, is trying to, convince people that you have an obligation, even though this is not a part of your property and it's not part of a common area. So this is trying to close that gap. That's one of the reasons we're recommending that we no longer allow those in private easements to avoid that situation in the future. But that would be an obligation on everyone in the development. It's actually written in the code that way now, that it's an obligation of the development, not just of those abutting property owners.
Maybe that would encourage the HOA formation. So,
yeah, definitely. That's what our hope is.
Mr. Jensen?
Yeah, thank you. I was just going to add to what Chad said, if that's okay. And what's driving this is really, well, I'll frame it this way. Most of the issues in this area have resulted because the HOAs were not properly established by the developers to begin with. Mm-hmm. And so, in addition to the ordinance proposal to change, is what Chad talked about in terms of the staff's review and critique of those CCNRs when they come to us, and our ability to write ourselves in as a partner for the purposes of the creation and the dissolution, potentially, of the HOAs is really, really significant. So under the code, the applicants without our approval or the developers don't have the ability to say, well, or the residents afterwards to say, well, we just don't want to be an HOA anymore. So what this is not, it's not the provision of an alternative to the HOA. The HOA is the alternative, but we're dealing mostly with 3 or 4 horses that are already out of the barn, and we're trying to not only close the gate on future ones, if that analogy works, but also to do a little spruce up of the barn itself, right? And where there have been intentional or unintentional manipulation of those regulations to be able to circumvent the proper creation of the HOA, we're closing those now, both by ordinance and by staff policy and a better, more thorough review of that. So what we think will happen is, and to Tina, I think to your question, staff does not intend to say to the developer or to an HOA, well, if you don't like to do it through the HOA, you can come to the city and petition us, and we're happy to accommodate. That's not about this. This is about situations where we have currently, where there are, let's say in a 3-phase subdivision, phase 1 and phase 2 were properly set up. Phase 3 wasn't properly set up by the developer, but yet the improvements were put in. And then as the HOA or the developers went back to the residents and said, okay, you're in phase 3, you need to join the HOA, create your own or join an HOA with 1 or 2. Mm-hmm. We have some residents who are saying, no, my landscape's being taken care of. I'm just fine, thank you. Even the phase 1 and 2 HOAs have said, we'd love to have you come in. We'll charge you the same fee. We already have a contractor that's coming out every weekend to take care of this. We'll just take care of yours as well. And we have residents, some who are saying, yes, sounds great, but others are saying, no, thanks. I like the idea of receiving this benefit and paying. In those situations is where we'll approach them and say, Mr. Jensen, you have this obligation that Gary's talked about and Chaz talked about as part of the purchase of your lot. That's something the developer committed to, and you inherit that as the purchaser of the lot. So in your case, you have the choice. One is you can join with the HOA that already exists. They've welcomed you in. We've had those discussions with them. Or if you insist otherwise, then the city has the ability for that fee. So the incentive is to help them to take advantage of the structure that already exists. Again, the problem has existed because the developers didn't set it up properly, and then there's no legal recourse for the HOA to go back and force those people to come in. I don't know if that makes sense or not, but we think it'll be, has a very narrow, a fairly narrow application. Most HOAs, Chad, you correct me if I misstate this, that are properly set up and the developer stays in long enough and gets the bylaws put together, most of those function well. It's when there's been a kind of a half-hearted approach to it or negligence, that's when it really can become a problem. And again, we can count them all in one hand. We all know where they are, that are generating 99% of these issues. So I don't, personally, you guys can disagree, but I don't think this is going to be an ongoing issue, what we've had in the past, if we just close these gaps, both in policy and by the ordinance, and then educate people. And the citizens, many of them we've met, Gary and Chad have met neighborhood meetings and evenings with people on every side of the issue, trying to encourage a cooperative approach to solve this on their own. And in these handful of cases, it simply hasn't happened. So that's why we've come to this place. But we think it'll quickly come back into to order, if you will, and shouldn't be an issue going forward. Any feedback on that, Chad?
That's exactly right. I think it's a handful right now. Most of them look like this. Most of them are very well maintained, some version of this, but there are a few exceptions that we're just trying to close that loop.
Okay. All right. Any other questions? Are there any comments from our audience? Keep in mind that this is a public hearing and we prefer your comments to be brief. Again, state your name for the record.
Just a minute. Tom Tudor, 1757 Gregory Drive, Layton, Utah, 84041, 801-773-5155. Yeah, you all probably know me by now. The retired cop that respects the people, the voters. Okay, and I respect all of you. And I want to throw into you, you're perfectly right. I'm the police officer and the detective that had to go to all those kind of houses because the sheriff had to go there for 30 days by law and not get anybody. Oops, knock something out here. And I would like to be invited to one of your legal and law meetings because I'm the one that had to take them all to the Davis County Jail because they wouldn't pay their monthly fees and they would hook up water to other houses and cheat and things like that. So for 20 years, I could come one of your little meetings already read out because I've done meetings at Layton High School for them. For a lot of information. That's why I come here and take notes, because I know the people after working here 52 years.
Okay, thank you.
And that's about it.
Thank you, Tommy.
Yeah, if you ever want me at a meeting to let you tell you about what really goes on, call me up. Thank you.
Okay, thank you. Is there anyone else who wishes to speak upon the topic? Okay, if not, I'll bring it back to the council for some action on item number B of our public hearing.
Madam Mayor, I make a motion that we adopt the proposed amendments to Layton City Municipal Code, Title 19 zoning, Title 19.05 general and specific development regulations, Section 000, Tables 5-1 and 5-2, and Section 30, requirements specific to residential and agriculture zoning, landscaping and fencing, Section 40, transitional landscape and fencing, and Section 90, landscape requirements for arterial streets, Ordinance 22-01.
And we'd like to, if we can include in that motion, those changes we talked about, the grammatical and typographical changes.
And Tyson, you skipped a line.
Did I skip?
Yeah.
Districts.
Yep, that line.
You want me to start over?
No. Just accept the
as
amendment.
written.
As written, yes.
Thank you.
Okay. Is there a second?
Second.
Okay, it's been moved and second that we adopt ordinance 22-01. I'll take a roll call vote on this. So I'll start down there with Mr. Thomas.
Yep.
Councilmember Edmonton Smith, Smith Edmonton.
Aye.
Councilman Morris.
Aye.
Councilman Bloxham.
Aye.
And Councilman Robert.
Aye.
Okay, it's unanimous. Let's go ahead and now go down to our final item of our public hearing, which is a rezone request. And once again, Mr. Chad Wilkinson will present this to us.
Thank you, Mayor, Council. This is our last item on the public hearings tonight. This is a zone change proposal at 178 West, 2675 North. This is a zone change request from CP2 to M1. The property's shown there on the screen in red, kind of up on the north end of the city toward Hill Air Force Base. This shows the property outlined here in yellow. The zoning, the existing zoning of CP2 is shown in red. The adjacent zoning of M1 is that gray. That's the proposed zone. The M1 zone is an industrial zone. CP2 is more of a commercial retail type of a zoning. You can see to the north we have an existing mobile home park. Also to the south, some additional property zoned commercially and then some more mobile homes. Properties to the east are zoned industrial, which is what the applicant's proposing. Just to show the property, if you remember, this was part of a recent subdivision amendment that the council just barely approved to adjust the common property line. That little property line is still shown there, but that would expand that property just by a little ways to provide for some additional building area. The applicant's desire is to build some industrial flex buildings on this particular lot, which is an appropriate use for that M1 zone. This is an area that's identified in our general plan for industrial flex. That is exactly in conformance with our general plan designation for that property. So we have reviewed this. Again, this is that plat you just approved. We have reviewed this request. The Planning Commission has also reviewed the request and unanimously recommends approval of this change from CP2 to M1. And I'd be happy to answer any questions if I can.
Any questions, Council?
Yeah, and we've had this meeting. I just want it said for the record, but on the left is a church. On the right is a school. Now they're open fields, so the kids, I assume, on the school side go and play. On the church, I'm not so sure. So help me out, what do we have that'll protect us that this M1 doesn't slide into an M2 kind of?
Well, this is the zone change is what protects that. It's a zone change to M1.
That's a start.
So that can't change to M2 without further council action.
Right, yeah.
So this M1 zone is our lighter industrial of the two industrial zones. It is consistent with the general plan. Some of these religious and educational uses are allowed in a variety of zones, including some of our industrial and commercial zoning districts. Sure. As far as the protections, there'll be buffer requirements along the perimeters of these properties. In the case of a church or a school use within the industrial zone, however, it's one of those inherent conflicts that we sometimes have. We'll have some landscape buffers along there. However, you've got some big space between the two uses there that'll provide somewhat of a buffer. We'll also have those landscape buffers provided in that area. But it's not a non-conforming use, but it is a little bit of a unusual use to have in that zone. But again, this is an appropriate use. Whether it was industrial or commercial, we'd still have those same transitional buffers required.
Right, but you also mentioned permits, like when you go to get your business license. There's things that they check out.
We would check the parking. We would check the use to make sure it complies with that M1 zoning.
Right, you would check.
We'd check compliance of the landscaping to make sure it's still functioning the way it's supposed to. If they've let things go for whatever reason, we require them to bring that back up to code.
Make sure they stay in an M1 zoning.
Yes, they can't change that M1 zoning.
Yeah, no, I understand they can't. A lot of people do things they can't do.
So I think I understand your question now. The uses they'll have to comply with that M1 zone, which we will check at business licensing.
My only concern is you got the school there, and then you have the church, which I don't know what they use that property for, but you have the ability of kids to be able to be around that.
And those uses are carefully monitored at the business license process. They can
that's what
only
I wanted
use those. Yep.
You to say so everyone else could hear.
Madam Mayor, do you mind?
Yes.
Councilman Thomas, I had the similar question. Can you just give me some ideas of what would be an acceptable use in M1 that would not be allowed in CP2?
M1 allows more light manufacturing type uses, could be some more industrial type uses rather than the CP2. CP2 was recently changed to have those light flex. This would allow things like outdoor storage, though, as part of a use potentially. It doesn't get into those heavy manufacturing uses like an M2 would allow, but you could have potentially like a contractor storage yard that would allow some outdoor storage of materials with proper screening. There's still requirements for screening
Bring that up.
and
Fencing.
and landscaping and fencing. Yeah.
I know we aren't to the site plan, and this is a zone change. Do we have any idea what the intent for the parcel is?
It's flex industrial space, so it would be individual spaces that would be flex warehouse office type buildings is what they've indicated to us.
Any other questions?
Yeah, is that okay?
Yep.
That school is a charter school.
Yeah.
I believe. I mean, I don't know that people are walking, kids aren't walking to that school. They're driven to that school, I would.
For the most part, yeah.
Okay, thank you.
Okay. If there's no more questions from the council, I'll open it up to the public. If anyone would wish to make a comment regarding item C of our rezone request. Please state your name and address for the records.
Name is JD Whitaker. Address is 1909 South Bluff Road, Syracuse. I am the applicant on record, and thought it was kind of exciting to get a couple of questions. We haven't even had a lot of discussion up to this point, but I thought some of the questions were insightful relative to the just proposed uses. And we've had kind of a general question of what an industrial flex use would be. I can provide some specific insights for us and the specific plan for this property. I think that the biggest distinction between a CP2 and an M1 is the ability to, which has already been mentioned, to actually have a secured contractor yard. The ability to essentially, if you maybe really just the ability to secure a yard where maybe you have a subcontractor with a fleet of vehicles, and you want to have the ability to lock that up. I think that's going to be the biggest driver as far as I think overall there's also measures in the permitting process that requires an attractive facade on the buildings that are already in place, as well as in this specific area, there's some CC&Rs in place that also even further restrict automobile storage as far as prohibiting junkyards, but that's probably already covered in the zoning. But I think overall there's existing restrictions that help the city that are already in place, that help the city accomplish, a good community and a clean property and an attractive use of the particular property. Overall, it's the intent is to build high quality professional office space that also allows subcontractors to have a simple warehouse storage option as well as a contractor yard. And it's that real driver of that contractor yard that's the distinction between the M1 zoning and the CP2 that opens up that option. So hopefully that provides a little clarification on kind of what we'd be seeing from that property in the future should we receive a recommendation or approval for a M1 zoning. So thank you.
Right, thank you.
I appreciate what you said. No, you're fine. I didn't want you to do anything different than anybody else. That was not. I trust you. I trust it's an M1. That's what you'll do. My only concern was that others, which I had to find out myself, understand that there's still ongoing things that make sure that stays an M1. And the only reason I did that is because you got all these kids here up against the fence. And I wasn't sure with the church, but the kids, they're all out there playing in the field. So they're going to be up against that fence. And yeah, I just wanted to make sure that there was checks going on, that nothing got there that was not good. And I didn't mean to make you feel like you needed to get up, and because I totally trust the system. I just wanted, with me, I was thinking, what if? And the what if was taken care of. But thank you.
Great.
Appreciate
Wonderful.
it.
Any other questions? All right. Thank you.
Thank you. Okay. Is there anyone else who wishes to speak on the topic? Seeing that there's none, council, I'll bring it back to you for action on ordinance 22-04.
Mayor, I move that we approve ordinance 2204.
I have a second. It was second by Bettina. Okay, so it's been moved and seconded. And once again, since it's a public hearing, I'm going to go ahead and do a roll call vote. I'll start out with Councilman Bloxham.
Aye.
Councilman Roberts.
Aye.
Councilman Smith Edmonton.
Aye.
Okay, Councilman Thomas.
Aye.
Councilman Morris.
I just want to thank you for, we worked on this to add that industrial flex part, something that Tim was all over before he left. I think it's added something to what we can do with land use here in the city. So I vote aye, but thank you. Thanks.
Thank you very much. Okay, that concludes our public hearing. So council, I'll look for a motion to close the public hearing. And if there's no other unfinished business, I would entertain a motion to adjourn as well.
I move that we close the public hearing and that we close the public meeting.
And I second that.
Okay. All in favor, say aye.
Aye.
Any opposed? Okay, thank you very much. Thank you for those that have stayed here the whole time, and I wish everyone a good evening.